Who would have thought to do that? So as I was saying, welcome to the August 11th, 2021 meeting of the Tennessee Real Estate Commission. At this point, we will ask our Executive Director, Caitlin Maxwell, to read into the record the public disclaimer and then, for the record, call the roll.
Notice of the August 11th meeting of the Real Estate Commission, including date, time, and location, has been noticed on the Tennessee Real Estate website since August 26, 2020. Additionally, this month's agenda has been posted on the website since Friday, August 6, 2021. Now for the roll. Commissioner Joe Begley. Here. Commissioner Jeff Diaz.
Here.
Commissioner DJ Ferris.
Here.
Commissioner Marcia Franks.
Here.
Commissioner Steve Gwen.
Here.
Commissioner John Moffitt.
Here.
Commissioner Joan Smith.
Here.
Commissioner Stacy Torbett.
Here.
Chairman John Grease.
Here.
You have a quorum.
Thank you, Caitlin. At this point, Commissioner Torbett will lead us in an invocation, and following that invocation, if you will please stand, she will then lead us in the pledge to the flag. Commissioner Torbett.
Dear Heavenly Father, thank you so much for the opportunity to be here today. Thank you for everyone's health and safety. They guide us.
Flag of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you, Stacy. You can get back your muffin at this point. All right, next up is to approve today's agenda. It was included in the package emailed to you. Any corrections or additions, deletions, or is there a motion to accept the agenda?
Move to approve.
A motion by Ms. Frank, second by Mr. Diaz, that the agenda be approved as presented and submitted. Next up is to approve last month's minutes. You also received those by email.
You want to do a roll call or voice vote on the agenda or not?
Thought we
did the motions.
You don't have to do it.
approve the agenda.
Yes, it was Franks and Diaz.
I know the motion. Did I ask for a vote on? Did I say all those in favor of approving the agenda? Please vote aye.
Aye.
Thank you, Jeff. Those opposed vote no. That motion passes. Next up, which will move smoother, is approval of last month's minutes. Is there a motion?
Move to approve.
Second.
I have a motion by Ms. Frank, seconded by Ms. Smith, that the minutes from last month be approved as presented. Discussion. Those in favor of that motion vote aye.
Aye.
Those opposed no. The motion passes unanimously. Next up are informal appearances. Candidate A. We have there's a candidate C as well, right?
No, there was just a candidate A and B. I believe candidate B has 2 documents that were sent.
What you sent on a separate email
Was for candidate A.
Now we're on candidate A. You want to give us a narrative of what we should know?
Yes. So I don't even have candidate A's name. Let me get my
But his or her broker is Sue Ace.
yes. Yes.
Maybe Sue can tell us. Is she online?
Yes. Sue, we started redacting all information. Is this Ryan? Yes. Okay. So before you have applicant Ryan Herbst and his principal broker Sue AC. He has taken the real estate timeshare exam. His principal broker has been licensed since 2014 as a broker and first licensed in 2010. The firm is Wyndham Smoky Mountain, and a summary of the criminal and disciplinary sanction is felony possession of marijuana. His statement and a letter of recommendation can be found in the packet.
So what is Ryan's last name?
Hey, Ryan, let me know if I'm pronouncing this wrong. It's spelled, I believe, Herbst. Is it Herbst?
Is the proper way to say it.
Sue, we can't hear you.
Herbst. Herbst.
Sue? I'm having a hard time hearing you or Ryan.
You may need to get closer to your computer.
That'll help.
Herbst. Herbst. B is like a T.
So Ryan, would you just state your name just so I can hear you talk for a minute?
My name is Ryan Herbst.
I'm still having, I need you all to get closer to the microphone in the room you're in. Thank you.
Is that better?
I can't tell yet. Tell me your name again.
My name is Ryan Herbst.
It's audible. Maybe it's on our end. Hold on one second, Ryan.
Here's the guy.
Yeah. Okay. So, Ryan, has Sue told you how this process works?
A little bit.
Well, let me just quickly say that in just a moment, you'll have the floor to tell us what got you to have to appear in front of this commission today. You can tell us as much detail as you want or as little. And following your story or statement, I should say, commissioners reserve the right to ask you questions. And following that, we'll ask Sue to tell us why she's interested in having you affiliated with her firm, Wyndham. And we'll also reserve the right to ask Sue questions. Following that, there'll be a motion of some sort, maybe to deny, to allow, to postpone, and we'll take a vote. And we'll take 5 votes, positive votes, if the motion is to allow you to go forward to get your timeshare license. Okay, any questions?
No, sir.
All right, Ryan, get close to that microphone. I think we're as high as we can be here, so give us some details. What happened?
Okay, so I believe it was 2015, 2016. I was making some mistakes in my life, just wasn't doing the right things, was traveling from Colorado to Tennessee, transporting marijuana. A lot of people that I've talked to actually say that it was one of the biggest mistakes of my life. It was actually the best mistake of my life because it's changed me thoroughly. I now attend my church every Wednesday and every Sunday, volunteer there every Wednesday and every Sunday. It's gotten me closer to my faith and closer to people who have greater interest in my life and want me to proceed and, be successful. I thank God for actually putting me in that position to be able to humble myself and go further. It was able to let me sit down and realize where I wanted to be in my life and what I needed to do. And I feel like that was a company with Wyndham. That's what I feel as well as a lot of the Sue and a lot of the other managers and directors have had my back here because they understand that I have grown a lot and been able to change and be a better person because of this scenario. And I also want to thank you guys for being able just to give me the opportunity to present myself and to be able to come back.
Commissioners, questions? Marcia.
Mr. Herbst, good morning. This conviction took place in Kansas, is that correct?
Yes, ma'am.
And you have finished your probation?
Yes, ma'am. I went and turned myself in a few years ago. My mother was hit in a head-on collision, and it caused me to miss my court date. So I went and turned myself in, handled all my things myself, was sentenced to 3 years of probation. I paid all of my court costs, did all of my community service and all of my classes in half the time. I was released 15 months early because of good behavior and no violations.
Ryan, let me interrupt for a second. We're still struggling to hear. Can you find the microphone and kind of spit in it, that close kind of thing, just so we can hear it?
That's better.
I don't know where the microphone is. Is this better or is this worse?
Just stand by.
Is that better or worse?
Come back up toward the screen.
Is that better or worse?
Better.
Keep coming.
Better or worse?
Better.
Okay.
Bless your heart.
Hey, that's okay. I'll stand like this the whole time if I have to.
That's all the questions I have.
I've come
Mr.
too
Chairman.
far. I don't plan on backing out now.
Other questions for Ryan? So, just a curiosity question, Ryan. How were you caught? What would you have? Were you on an airplane or in a car, or what was going on?
It was actually, you know, if this doesn't tell you that God has a plan for you, I was actually going 76 in the 75 and got pulled over. I personally believe it was just destiny meant to happen. In my affidavit, it said I was going 76 miles an hour in a 75 mile an hour zone.
Did you have like a bale of marijuana, or how much were you carrying?
No, sir. No, sir. It was just 5 pounds of marijuana.
Just 5
Just
pounds.
5 pounds?
In a duffel bag.
Wow.
I'm not El Chapo. I did not have a car full, just a duffel bag. So.
Fit in here. So, what have you been doing since, well, say the last 2 or 3 years?
Well, I've been trying to really get my life together. I've been making sure that I've just taken care of all of my previous, mistakes that I've made in my life. I was working for the Knoxville Firefighters Association for over a year and a half. I was raising money for their union. The firefighters themselves chose what they were going to do with the money. I'm a regular attendee at my church. I volunteer twice a week, every Wednesday, every Sunday. Just really trying to make sure I keep my nose clean and trying to surround myself with the best people possible.
So, let's get Sue first here. Any other questions for Ryan? If not, Sue, we need to hear from you. Tell us why you're interested in this fella.
There you go.
That's nothing much. Ryan worked for us before. Can you hear me?
Oh,
Ryan worked for us before. And he made the stupid mistake of leaving and going to work for somebody else. And he discovered that Wyndham was where he needed to be. He did good work for us before.
hey, Sue. Sue, we can't hear you. I think I'm just going to take the motion offered by Joe Bagley and see if I can get a second.
Second.
I've got a motion by Mr. Bagley, seconded by Ms. Franks, that this applicant be allowed to proceed to get his timeshare license. Sorry, Sue. I didn't-
Thank you all so much.
Not yet. We haven't voted yet, Ryan. All right. Is there further discussion? Other questions? The motion is to allow Mr. Herbst to go forward and get his timeshare license. If you're in favor of that motion, please vote aye.
Aye.
If you're opposed, vote no. All right, Ryan, you squeak by.
Thank y'all very much.
Hey, thank y'all so much.
Good
Seriously.
luck. Take care. All right. I knew I didn't like WebEx. Candidate B, Caitlin.
Okay, candidate B is Dan Bickley and his principal broker, Johnny Daniels. Mr. Bickley has taken the Tennessee Real Estate Affiliate Broker exam. His principal broker has been licensed as a broker since 2003 and first licensed in 1996. The firm is Premier One Realty, LLC. And a summary of the criminal and disciplinary sanction is conspiracy to distribute and possession with intent to distribute, Schedule 1, and conspiracy to commit money laundering. His statement and letter of recommendation can be found in the packet. This candidate was previously licensed, so we have included this charge resulted in their license being revoked previously due to the failure to notify the commission. So you will see all of that.
What's Mr. Bickler's first?
Dan.
Bickley. Okay, so let me see if I can say this back to you, Caitlin. So this fellow at one time had a license with the Tennessee Real Estate Commission. He was convicted of a felony, failed to report that to the commission, which is an automatic revocation after a certain period of time.
Correct.
And so how long ago was that revocation?
So I believe it was in 2016 was the date of the revocation. You will see included the letter that the department sent was from February 2016. The actual charge, I believe, and Mr. Bickley can correct this if it's incorrect, was from 2014.
It took the state 2 years to find out by some method that he'd been convicted of a felony.
Correct.
Okay.
I don't know if the 2014 date is the charge date or the conviction date.
Commissioners, understand what the situation is before we get started?
Question.
Yes, Steve.
Was it 2 felonies or 1 felony?
Anna is going to tell us.
Says one count of engaging in monetary transactions of property.
I'm looking at the court sheet. So money laundering.
So if you look on the document that's signed by Mallory, you'll see in the first paragraph, it states that Mr. Bickley pled guilty to 1 count of conspiracy to violate the Controlled Substances Act by distribution and possession with intent to distribute Schedule I controlled substances, and 1 count of engaging in monetary transactions and property derived from specified unlawful activities. So it's 2 counts, 2 separate counts, but both of the counts are felonies. And just for clarification, I think 2014 was the date of the arrest. Mr. Bickley was not sentenced until November 30th of 2015. And we were notified, this letter of revocation went out February 2016.
Says he was indicted January 2014 and pled guilty September 2014.
Right. So he was sentenced, his prison sentence was November of 2015.
So he pled guilty to 2 counts, 2 different things, correct?
Correct.
All right.
So I don't know that we have the letter Mallory signed.
Yeah, it's at the very first thing.
Is it?
There's 2 different entries for this.
So if you were looking at the documents that were sent to you, this was the first document. It looks like a letter with the state seal.
All right, Commissioners, are you up to date on where we are before we hear from the applicant? Any other questions? All right, Mr. Bickley, can you hear us? I think you may be muted. Mr. Bickley.
Can you hear me?
Thank you.
Yes.
Have you been listening to our discussion?
Yes, sir.
Did you hear anything that you didn't believe to be correct?
No, I got a little confused on the dates, but
If you're okay with the background we've been provided, it's your turn now to provide us with information that you'd like for us to know about the event or events, what you've been doing since then, why you'd like to get in real estate, whatever you'd like for this commission to consider.
yes, sir. In the year 2012, I operated a retail store in Bristol, Tennessee, and we sold what at the time was called K2. It was synthetic marijuana. It was legal in the state of Tennessee, and we paid sales tax on it. I wasn't aware that it was illegal federally, and it was. And I found out when I got arrested, and I pled guilty to the charges. But it was sold not on the corner. It was sold in a retail store. We paid Tennessee sales tax on it because I thought it was a legal product. And if I had known it was illegal, of course, I never would have sold it.
So were you arrested by a federal agency?
Yes, sir.
Who was that, just out of curiosity? FBI?
The DEA.
Okay.
Okay.
Questions, Ms. Franks?
So, Mr. Bickley, you were running this store. What else did you sell besides synthetic marijuana?
It was a smoke shop. We sold posters. We sold tie-dye T-shirts, headbands, that type stuff.
And you sold any other drugs than this?
No, ma'am.
And so when you were in Virginia, how did you find out that it was illegal in Virginia?
In the news, the governor had banned it, and that's how I knew it was illegal in Virginia.
And how many stores in Virginia did you have at the time?
Just the one, Bristol.
So how long did it take you to close down that store?
About 3 days.
Okay, and so you heard that in Tennessee. Where did you get your information from that it was legal in Tennessee?
Well, because everyone was selling it. All the stores were selling it. The gas stations, everyone was selling it. And we paid sales tax on it for several months.
But something caused you to move from Virginia to Tennessee. So you didn't do any investigation with the state. You just took it for granted that it was legal in Tennessee?
Yes, ma'am. I mean, I had an attorney. We stopped selling it in Virginia because the governor banned it.
Okay,
Even
so
though it's a legal substance.
so how many of these stores did you open up in Tennessee?
2.
2 stores.
Bristol and Johnson City, yes, ma'am.
Okay, so was there an undercover person that came into your store and bought it?
Yes, ma'am.
And did you tell them you were making $10,000 a day selling it?
They asked what our sales were. Yes, ma'am.
So you were making $10,000 a day selling this.
Sometimes, not always, but sometimes.
Okay, well that's quite a bit of money. So so when you were arrested, did you serve any time in jail?
Yes, ma'am.
Where did you serve time?
Manchester, Kentucky.
In a federal prison?
In a federal camp. Yes, ma'am.
And how long were you there?
Approximately 16 months.
Okay, 16 months. And
Yes,
so
ma'am.
were you ordered to pay restitution?
No, ma'am. There was no restitution ordered by the judge.
So you just got
No fines.
the 16 months and no fines, no court costs, nothing else?
Correct. Nothing else.
Okay, so and so that was 6 years ago.
Yes, ma'am.
What have you been doing the last 6 years?
Working in the hotel business for Marriott. I was in Jackson, Tennessee, and I'm just finished doing a task force job, which is temporary hotel manager, over in Johnson City, Tennessee. I've been in the hotel business off and on for about 15 years, but I was general manager of the Marriott Courtyard in Jackson, Tennessee.
So where's your residence now?
Bristol, Virginia, about 1 hour from about 1 mile from my broker's office.
So you don't live in the state of Tennessee?
No, ma'am. I live in Bristol, Virginia, and Bristol's a border town, of course.
Yeah. Okay, that's all I have for now.
I would just like to chime in and provide some additional context for the commission to be aware of. So you should have a copy of the plea agreement from the district court. Do you have that document?
Likely.
It begins. It says plea agreement is the first, and it says at the bottom of the page 1 of 25. I think that's in the second section of information.
Same section as that last piece. Already got it?
Okay.
You have it?
Yeah.
Okay. I'd like you to turn to page Hold on 1 second. To page 21 of the document. Okay, we there? Okay. So we're looking specifically at paragraphs 11 and 13. There's not a 12, so you're not missing anything. Uh, Paragraph 11 talks about the special assessment, and then paragraph 13 talks about the agreed preliminary order of forfeiture. So he was required to forfeit several different assets and property. And so that begins on the bottom of page 21. You'll see exactly what amount of currency was forfeited. Then if you go to page 12, you will see additional amounts of currency, real property, and a money judgment. So that is additional information for you to consider regarding this particular set of charges.
So I'm wondering, when you said that there was nothing, nothing that you had to pay, no court cost, anything, how do you explain all of this then? Because it shows they took several pieces of property, they seized a safe and a safety deposit box of $100,000. Another one of 65,000, and another one of 274,000. So you just told me there was no money involved in this. So how do you explain that?
Well, I understood your question to say, had I been charged with any fines or penalties or whatever? But yes, they did seize. I bought things for people. And they did seize assets of things that I had purchased and cash that I had in a safe deposit box. I misunderstood your question to ask you if I had to pay any court costs or fines or penalties. I was not trying to mislead you. I apologize. But yes, they did seize all those things that are listed there, including cash and property and vehicles.
Okay, so the next paragraph says money judgment. A personal money judgment in an amount of not less than $2 million, which represents the minimum amount of money. Is that true?
No, I don't understand what the $2 million is representing. I didn't have $2 million, if that's what you're asking.
Oh, is there a judgment against you for $2 million?
No, ma'am. There's no judgments or nothing against me.
So I'd ask our attorney, how could that be possible?
It's not.
So that's not true. There's two of them. One's at $1,250,000.
There are two money judgments listed. The first one is for $2,047,116.36. The second amount is $1,250,314.97.
And so is it your testimony, sir, that you've not paid any of that back?
I don't know of any judgment unless you're talking about taxes.
No, I'm looking at this document that came from the federal government that gave you a money judgment. I'm very worried that you don't know about a $3 million judgment against you.
Absolutely, I am too. I've not seen that document. I'm not aware of it. Could I have you send me a copy of it so I can look at it?
Would you like to withdraw? Would you like to withdraw?
Is that in addition to everything that was?
All of that stuff was seized, and then this is in addition to that? Or did that make up the $2 million?
That was probably what was seized.
So the currency.
No, it's currency.
The currency that was seized, you'll see in paragraph A, states $100,000. Paragraph B states $65,000, $65,800, and C talks about $274. I'm not great at math, but that does not
Didn't know if all the properties and
the
stuff were
money
included
judgment.
to satisfy that. Like they just seized everything he had to satisfy the $2 million.
Correct.
It doesn't say that. It says money judgment. That's different.
Joe.
So at one point you said you had 2 stores in Tennessee. Was there not a Mountain City and a Kingsport store also? Or are those not yours, or
Those were not mine, no, sir.
they were not yours?
Correct.
Okay. And then secondly, these other stores that you were just following their lead, you said all the other stores were selling it. Did they get in trouble
Yes, sir.
too? Did they get in trouble
Yes,
too?
sir. Yes, sir.
So all the convenience stores, somebody else went to jail for all that?
Yes, other people were charged, were convicted, and went to jail as well. Yes, sir.
At retail stores like yours or the convenience stores, or both?
Both.
So I'm gonna chime in again about the different locations. So if you see the immediate press release from the Department of Justice, that document is provided to you. It should be like right in front of the plea agreement. It's 2 pages. So I'm looking at the second paragraph. Are we there? At the
One second.
top, it says the Eastern District of Tennessee. It looks like a document from a web page.
Still in A, right?
Candidate
First
B,
one?
Trek Docs redacted.
Yeah, it's in that first group.
Page
It's in
3.
that first group that we went to.
Mr. Chairman,
Yes, Steve.
question when Mr. Bickley, I'm curious.
Yes, sir.
About, is
Wait a
that
minute.
Anna's wants to point something out.
She's making a point.
okay?
And
Just want to point something
All right,
out
sure.
to you guys. So in the second paragraph, you will see kind of a history of the charges that are provided. It tells you about the specific substances, synthetic drugs to include stimulants, bath salts, and cannabiomimetic substances, which is also known as fake weed and incense. You'll also see it states he first operated a location in Southwest Virginia, and then through a business called Cloud9 in Bristol, Tennessee, and then opened additional Cloud9 locations in Johnson City and Mountain City. And then after that, it states White Cloud Emporium was located in Kingsport, Tennessee, and operated by another person.
Right, that was not listed.
Okay.
That's more than one location.
So, Joe, does that answer your question? Steve?
I was
Since he was involved.
right. So it's more than one location, which I think is what you were asking.
4 locations.
Okay, Steve.
Yes, Mr. Bickley, I'm concerned about this money laundering aspect of the felony.
Yes.
And on page 16, it talks about transferring money to the Lesters in multiple occasions, and it seems so. My understanding of money laundering is when you have money that you can't deposit in a bank because it's illegal, then you transfer it other places to launder it, if you will. So if you were kind of saying you're innocent of not knowing that what you were selling was illegal, why did you launder it? If you thought that the money was legal, why did you? It's pretty involved schemes here about transferring and going to a Volkswagen dealer and all this kind of thing. So it seems to be inconsistent to me, but I may be wrong. Could you enlighten me on that, please?
Yes, sir. From the laundering charge was, for example, if you go to the bank and let's say you purchase a money order, anything over $10,000, of course, has to be reported to the IRS. I know that now. I didn't know it at the time, and I did that several times, and they called that money laundering. Regarding Mr. Lester, I gave them money to buy a car and gave them money to purchase a home with.
Sounds like money laundering to me.
Now, Mr. Bickley, why were you keeping cash in safety deposit boxes instead of putting it in a CD or a money market account? Why would anybody do that?
Well, I had $100,000 that I was saving to give $25,000 to 4 of my nieces and nephews for a college fund, so I put it in the safe deposit box.
Instead of putting it somewhere where it would earn interest?
I should have put it in a CD. Yes, ma'am.
So, in other words, you knew that this money could not be, it wasn't legal money, so you put it in the deposit boxes, correct?
Incorrect. At no time did I know any of this was illegal money. I thought I was selling a legal product, and that's why I did it. I had no idea this was illegal money until they put handcuffs on me and said, "You're being charged for selling drugs illegally."
And you do realize that this is signed by let me get to it. Hang on a second. It's signed by the United States Attorney, and it's signed by your attorney, and then there's a blank that's redacted that I would imagine is your signature. So you agreed to all of this, correct?
I agreed to plead guilty to the charges, yes, ma'am, and to the forfeiture of the property and of the cash, yes, ma'am, because what I did was illegal.
Okay, so did you agree to all of that to get a lesser sentence?
No, that was the plea agreement that the attorneys worked out.
That you agreed to?
I agreed to the deal that the attorney had worked out, yes, ma'am. He suggested that I agree to it, and I did. But here again, I don't want to mislead you or if you misunderstand, because we're talking about money laundering and hiding money and putting it in a safety box. I thought the entire time of this, when I was operating my store, selling the products, I thought legally, so therefore I thought the money was legal. I was not trying to hide money because I knew it was illegal or anything like that.
Well,
so the other money that you put in the safety deposit boxes, if that wasn't for your family members' college, what was it for?
That was for my retail store.
Why were you putting it in a safety deposit box?
I was basically just saving cash.
Oh, I understand. As a business owner, I understand. What I don't understand is why you're putting cash in a safety deposit box instead of putting it in the bank. And the only reason I can think of is that it was illegal money, and that's how you were hiding it.
Well,
anybody else got any questions?
I respectfully disagree with you. What I was doing was I was saving money so that I could give money to my 4 nieces and nephews, who are obviously minors right now, in a safety deposit box. And yes, it would have been better if I'd purchased a CD in their name, but with it being minors.
I was wondering if I could make a proposal. Mr. Bickley does not appear to know the documents of the plea agreement very well. So my suggestion is, if the commission is okay with it, is that we provide him a copy of this document and he reviews it, and then he can make a determination whether he wants to come back to the commission next month or not.
I'm not disputing the documents you have in front of you that have been prepared by the attorneys or what I agreed to. I appreciate that offer, but it's not necessary. I agreed to whatever my attorney recommended that I agreed to because I was guilty. I was guilty of committing a crime. I did not knowingly commit a crime. I thought the products I was selling was legal, but they weren't. But I don't need to see the documents you have because I'm sure if my attorney's signature's on there, my signature's on there, that's what I agreed to.
And I'd like to make
Wait. I want to go Stacy first, and then Steve and DJ, in that order. Stacy.
I got a couple questions because I still don't quite understand. So were you selling legal products that some had illegal substances in them? Or were they legal just in Tennessee but not federally? I'm just really trying to follow along with what
it was legal federally at the time. It was legal in the state. I paid sales tax on it. Virginia banned it, but Tennessee still allowed the retail stores and the gas stations to sell it. So I sold it in Tennessee. But the whole time, none of us knew, none of the other store operators knew that it was illegal federally because of some of the products that contained it.
And my question, I think, that kind of goes along with what you're saying. Was this reported as income? Like, did you pay income tax on this? I know you said you paid sales tax, but did you report
Yes,
this as
yes.
income? And so you paid.
Yes, ma'am.
Okay. Okay.
Steve?
Mr. Bickley, on your sales, help me understand, when you went to the safe deposit box to put this cash in, did you segregate the money from the legal sales and what turned out to be illegal sales? For example, you were selling T-shirts, which are legal. So did you take the money from just the marijuana sales to go to the bank to put in the safe deposit box? Or did that money include, I don't know how you kept track of what was legal and not legal if you thought the marijuana was legal. You see what I'm saying? Because it sounds to me like you knew it was illegal. I'm having a hard time understanding how you thought it was legal, yet you went to the bank with illegal money and put it in a safe deposit box instead of depositing it to your bank account, which was the normal course of affairs. You know, you have a bank account and your receipts for the day, et cetera. See what I'm saying?
Right. Well, the reason I put it in the safe deposit box was not to hide it as illegal money or drug money. In my mind, my intentions were I was going to save $100,000. I've got 4 nieces and nephews, and as they got older, I was going to give them that money for college. I should have put it in a CD, but I didn't put it there to separate it from my other sales income, if that's what you're asking. No, sir.
So you didn't segregate
no, sir.
the money out, so you just put money in a safe deposit box, and it could have included
correct
T-shirt sales or whatever, posters.
Yes.
Okay.
Yes, everything.
Thank you. How would you characterize what you sold? Describe what you sold to us. Like,
you mean the product?
right, the product you sold. How would you characterize that and its benefit to society or impact on the community? How would you describe that?
Well, it was a mistake. And the big lesson that I learned from this was just because you can do something doesn't mean it's the right thing to do. And obviously I wished I'd never done it. It was a huge mistake on my part.
Okay.
And I served my time, and I apologize for it.
Can you describe, thank you for that, can you describe the typical buyer who would come in there and purchase this product?
Yeah, everybody, off-duty police officers. And I say that because a gentleman come in one night and opened his wallet to pay, and his badge was there. Doctors, nurses, average people, everybody.
But we're not talking marijuana here only. These bath salts were hallucinogenic drugs, correct?
Yes, ma'am.
And it was a new drug that was just, I remember there was a story, I think, out of Miami where somebody had been on those bath salts and they went crazy on it and ate a guy's face off, killed him. So they're these crazy new drugs, and I guess it had not gotten to Tennessee yet until we started hearing about it from other places. Is that why it was not illegal at the time?
Yes, ma'am.
And did you know this drug would do that?
No, ma'am. No, ma'am.
What did you think you were selling? What effect did the bath salts have on people that you were selling?
I don't know.
So you're just selling something? Okay, I'd like to make a motion.
I refused it, so I don't know.
I know you do. You're going to get to make the motion, but I'm going to go to Mr. Bagley, Ms. Torbett.
Yes.
I guess my last question is, in this documentation we have, there's they state that you would send someone to Florida with cash to Largo, Florida to buy product. I mean, in a legitimate business, I mean, did you think that you couldn't just send a check or something like a normal, to send a lot of cash with the driver to Florida? Did that happen? Is that true, or?
It happened, or it's true it happened. I didn't do it. My manager did. I found out about I found out about it as it was in progress. Apparently, some of these items, and they usually came in through UPS or FedEx, but apparently one of the deliveries got intercepted or got lost, and so my manager got the cash out of the safe at the store and sent someone to Florida, and I found about it when they was halfway on the road. But here again, we still thought we was buying a legal product. It was a mistake. It was a huge mistake. I regret it ever happened.
I'm just curious. So I'm sure you were seeing on the news that the ERs didn't know how to handle these people. It clearly was bath salts. Were you ever concerned about what you were selling, that it might be dangerous?
Well, I stopped selling the bath salts when I heard about all of this stuff. But like she said, it was on the news about somebody took a lot of the product and almost overdosed, and they chewed somebody's ear off or something down in Florida, whatever. So about 4 days later, I stopped selling the stuff and just sold the synthetic marijuana because it was on the news. People were getting hurt by it, and I stopped selling it.
So you stopped selling that voluntarily, and then you
Yes,
were charged with selling synthetic marijuana. So you weren't charged with selling the bath salts? Your charge was just for the synthetic marijuana?
Yes, ma'am. To my knowledge, the way it reads, it's controlled substance. It was. I don't think I was charged with the bath salt because we stopped selling it.
Before we get to, if we get a chance to get to Mr. Daniels, I have one more question for you, Mr. Bickley.
Yes, sir.
You lost your real estate license not because of the conviction, but because you failed to disclose the conviction to the Real Estate Commission. And I'm curious, what type of license did you have at that time?
I don't believe I was a broker then. I've had a broker's license and I had a real estate agent license, both with Tennessee in the past. And with everything that had happened with the charges, and I totally just failed to notify the Real Estate Commission about the felony conviction. Yeah. And obviously, I wish I had.
Do you recall if your license was with a company that someone else owned, or did you own it?
Oh, at that time? Okay. At that time, I was a broker, and I had my own company called the Real Estate Place. I was a broker in Tennessee and Virginia.
Oh, you were the principal broker, I suspect. You'd be familiar with the rules and regulations that govern Real Estate Commission, correct?
Yes, sir. Yes, sir.
So you knew you were supposed to tell, you just didn't. You got tied up doing something else.
Well, something like this that's so traumatic where you don't think you're selling a product that's wrong. I shouldn't have sold it, but I just got so overwhelmed with the charges and having to close my business and planning on going to do my time and serve my time that I just failed to notify either one, Tennessee or Virginia. And for that reason, my license was revoked.
Okay, thank you. Mr. Daniels, are you with us?
Yeah.
Have you?
Yes, sir.
Have you heard anything today that you didn't know before this meeting?
I knew about the biggest part of it anyway.
And you'd still like to have this gentleman associated with your firm?
Well, I've known Mr. Bickley for about 12 years. He's worked for me off and on for, about 10 years, and he's always done a good job. And, he does what he's supposed to do. Like if I tell him to do something, he will do it. And just like all the paperwork and stuff that he is supposed to get signed and take care of, he does that. The escrows, he's taken care of that and given that to me where I put it in my escrow account. And like I said, he's always been a good real estate agent.
So, what do you put in your escrow account? He hasn't been licensed with you, has he?
Oh no, I don't put anything in his account. I mean, in my escrow account, because he hadn't worked for me in about 8 or 9 years, I guess. He run his own real estate company and his own business. He didn't work for me then. And he worked for me on and off before that.
Any other questions for Mr. Daniels? Yep, Ms. Smith.
Did he work for you at the time?
Your microphone.
Work for you?
Joan, you might make sure your red light is coming on right here.
Joan, you don't have to push down speed.
Okay, sorry. Was he working for you during the time of the conviction?
No, ma'am. He was out on his own. He had his own business.
Okay. Other questions for either Mr. Daniels or Mr. Bickley? Let me go. Do you have a question? Okay.
I was just going to chime in. We are showing that when he was revoked, Mr. Bickley was an affiliate broker, and it appears that he was with this firm.
I'm sorry, would you repeat that? He was with me when?
Our system shows that Mr. Bickley was an affiliate broker when his license was revoked. And I show the last firm that he was with as Premier One Realty.
I'm not real sure about that. Like I said, he run his own business. He left here in his own business, side of his retail store, and I don't recall him coming back here after that.
All right. Any other questions for either the applicant or his proposed broker? If not, Ms. Franks has the floor.
I'd like to make a motion that we deny this request.
Second. I have a motion by Ms. Franks, seconded by Mr. Moffitt, that the request be denied. Discussion on the motion. Yes.
I'd like to recuse myself. I'm from that area, and
Okay.
just feel like I can't make an impartial decision.
That's cool. All right.
I think I'm gonna do the same, just because I remember, I'm not familiar with this candidate, but I am familiar with the entire situation in Northeast Tennessee, so it does make it hard to have an unbiased opinion.
Perfectly okay. All right, the motion on the floor is to disallow this application, for lack of a better way of stating it. If you're in favor of that motion, you'll vote yes. If you're opposed, no, when we call for the vote. Any further discussion? Everybody understand the motion? If you're in favor of that motion, please vote aye.
Aye.
If you're opposed, vote no. That motion passes. All right,
Who was
gentlemen.
the second on that motion?
John Moffitt. All right, gentlemen, thanks for being here today. Miss
Fresh Start Act. The Fresh Start Act.
So tell me the questions you need to know.
Okay, so
Oh,
we have
the
to
first
go.
Go through the first start.
Yeah, we have to go through. Well, the good thing is there are only 4 factors now instead of 6 that we're going to discuss. So since we are denying Mr. Bickley's license due to a prior criminal conviction, one of the questions, I'm going to read you different factors, and I need a conversation about why those factors you have thought about them in relations to this license. Okay. So first is the relationship between the nature of the crime and the purposes of regulating the profession.
I think the number one reason I made the motion is because there was not a credible witness before us today. So it's hard to determine when you don't have a credible witness. The nature of the crime, this involves money. This involves a person making $10,000 a day and bragging about it. And because of the nature of the real estate business and having control of money, that's the largest investment for most people. I would think that this person should not be allowed to be in real estate because of that.
Jeff?
I'll just echo what Commissioner Frank said. I just because of the money laundering charges and the real estate business obviously involves a lot of money changing hands, being trusted with other people's money, and I couldn't support the request.
I think that one also kind of relates to subparagraph B, which states the relationship between the crime and ability, capacity, and fitness required to perform the duties and discharge the responsibilities of the profession.
And if I could just add, my other concern is that the licensee is under no obligation to disclose their history to clients. So the client does not know the history of a particular licensee except by reputation and by recommendations. I have to think that if the consumer hears about this history, it would affect their decision about whether or not to allow a particular agent, in this case Mr. Bickley, to represent them in a transaction.
Next factor is any evidence of rehabilitation or treatment undertaken by the individual that might mitigate against the relationship of the crime to the profession.
We were offered no evidence of rehabilitation.
The only thing that I considered is the relationship with a respected brand as Marriott. However, albeit very briefly, didn't feel there was much remorse as to what was committed.
And D states any applicable federal laws regarding an individual's participation in the profession, and that factor does not apply. So I'm going to read a statement for the record that will also be provided to Mr. Bickley in letter format. The Tennessee Real Estate Commission on August 11th, 2021 decided to deny your application for licensure as a result of your conviction from on or about November of 2014 for the offenses of conspiracy to distribute in possession with intent to distribute Schedule 1 and conspiracy to commit money laundering. The Commission has decided to take this action after considering the factors previously stated as set forth by the Fresh Start Act. If you wish to contest this determination, you may file a petition within 30 days of the receipt of this notice in Davidson County Chancery Court, at which time the Commission must demonstrate by a preponderance of the evidence that the applicant or applicant's conviction is related to the profession. That's all.
Yes, ma'am.
I'm just very concerned that he doesn't seem aware that he has a very, very large restitution associated with his name. Anyway, that's just an aside. I would be concerned if I owed $3 million to someone.
All right.
And that the principal broker wasn't aware that he worked for him previously.
So the chair is going to rule that this matter is over. We're going to take a 10-minute break, and we'll be back in session at about November 10th, 9:48. Oh, we used to have one. Okay, Caitlin, we're on to waiver requests. Brian Clark, first one.
That is correct. We have 4 waiver requests. And the first one is actually related to E&O insurance. So the licensee did not have an expired license, but they let their E&O lapse. And just obtained the E&O, I believe, as of August. Let me pull the specific one up. Their E&O was suspended on January 29th, 2021, and they obtained E&O effective 8/2/2021. So this request is for the fee associated with an E&O suspension. And within the first waiver request, that's just titled 04, you will see a letter and a doctor's note.
Commissioners,
Can I make a motion, or do we
Sure.
want to discuss
I'll take
it?
a motion.
I think because of all the information, this man had a kidney transplant, and he has all his letters from Vanderbilt and his doctors. I think it's reasonable that we vote to accept this man's request.
Second. Motion by Ms. Franks is seconded by Mr. Diaz. Is there discussion? The motion is to grant the request. If you're in favor of that motion, please vote aye.
Aye.
If you're opposed, vote no. That motion passes. Mr. Barnes.
Okay, so this one is a little bit unique. So I'm going to walk the commission through this instance. So Mr. Barnes, his license expired December 1st of 2019. We had, which some of you that might have been on the commission at the time might slightly remember, there was about a 2-week period where we had some system issues where the system quit looking for the continued education. So there was a group of licensees that paid their renewal fee and their license renewed. So we caught this a couple days, I would say maybe a week or so after it happened, but it did affect probably around 100 licensees. And we sent out communication via letter to these licensees, giving them a date to complete the education by and letting them know of the issue. And we did send some follow-up emails. I will say this particular licensee didn't have an email on file, so I don't believe they would have gotten the emails, but they would have gotten the letter, or the letter would have at least been sent to them, stating that if they didn't have the education by X date, then their license would revert back to an expired status. And so this licensee came to us recently unaware that their license was expired due to their belief that they had renewed it. And I show that they paid for their renewal on October 4th of 2019. We never did have any education on file for this licensee for that renewal. But in the attached documents, they say that they did complete this education, and Ross and the licensee have reached out to the education provider. The education provider also had a change of ownership at the time, and they don't have, at least my understanding is they don't necessarily know, but they believe that this licensee could have taken the education and due to their change in ownership, not have reported it. He breaks down his account of the situation, and he also included, I asked if he could supply any potential proof of payment of the education, or if he had potentially gotten any emails confirming his completion of the education. And he supplied, and I've only given the commission a portion that seemed relevant, of his tax, of his business tax statement, that attributes $115 towards education. So that's essentially the situation at hand. Within there, you will see everything that he has supplied.
Let me make one quick statement. Okay, so I'll recuse myself on this topic. I've had discussions with this licensee, with his broker, with Caitlin. I suggested, because Caitlin is staff is kind of in a tough place because they've got rules they've got to go by. And one rule says if you don't get your education, you can't get your license renewed. Another rule says, after you look at the statement from D&D school that he did his education, we may have failed to send it in. Well, that puts, there's another conundrum for staff because rules say that education providers have to turn evidence of classwork within, 10 days or so. And clearly, if Mr. Barnes is telling everything correctly, then it was the school that didn't send education in. And so this is a unique situation. I don't think we've ever had one before. Typically, if somebody misses their deadline, they're stuck with whatever the penalty is. But in this case, Mr. Barnes will make the argument that he got the license from the state, he paid the money, he took the classes, he thought he was good for the next 2 years. But in fact, D&D at the school at that time alleges or acknowledges that it's likely they didn't send the education permits or credits into the state. So staff has done everything by the book here, and in this particular case, they're looking for guidance from the commission as to whether or not Mr. Barnes should be allowed to get his license. Mr. Ferris. Oh, okay. Steve.
Sure, you're red. Make sure the red. Yeah.
Did D&D make a mistake on anyone else? Or, in other words, this non-reporting by D&D, did it happen to other people?
We aren't aware of anyone else. This is a unique one, I think. Ross, make sure your mic is on as well. You got to unmute that.
This is a unique situation, Commissioner. I think that the gentleman who owned for many years one of the earliest providers in Tennessee, he passed, and then there was his name was Dick Clemmer, but at any rate, that the ownership passed to another bunch of folks, and then they in turn, that's what they have come up with here. That's the situation they have. So it kind of fell in their lap. Again, I think it is a unique situation with this.
But we can't find other people that may have taken a class with him that were in the same boat or that got reported. I mean, it just seems like
They may not know.
I'm just asking the question.
You'd have to turn in a whole class at one time. You wouldn't turn them in just individually. So I would imagine that there are others. We just don't know about them yet.
I think also there might have been others closer to 2019 that realized, hey, I took this course and it didn't get reported. And so it's hard to answer. We don't have anybody else in this particular situation of, we're now almost a year and a half. We could have had maybe people that reached out closer to 2019 and it was caught earlier, but we don't have anybody else looking for the education,
from that specific school for that particular time period.
Yeah.
They didn't need the hours.
Yeah,
Maybe they didn't need the hours.
But we have forms here that has D&D on it. Did D&D provide this that shows that he took the classes? It has their so they've a course completion form, and it shows that he's had, according to them, 16 hours.
So when we reached out, I think he reached out to them, and I don't know if I could dig for the email that they sent. But to paraphrase, and you correct me if you have a different understanding, they essentially said there was changeover at this time, given everything he's saying, given how many courses he's previously taken with D&D. Given the issues we were having at the time, we have reason to believe what he is saying. And they said we would be happy to backdate and provide the education. We decided to bring it to the commission because it is a unique situation. And
What are we asking for? Because the fee request, this is a waiver, and the fee request is $0.
well, it's $0 because Mr. Barnes did pay the renewal fee prior to expiration, and according to his account, he did do the education as well, which would have renewed the license. The reason it's here before you is because we did not get the education to renew the license, which is why the license was set back to expired. And I think, as John mentioned, the rules that we have to go off of require the provider to submit the education within 10 days, require the provider to keep record of the education.
So is he just asking that we make him active again? It's not a fee waiver? Or what?
It would be active again. It would be allowing D&D to provide this education past the 10 days and
well, it doesn't look like it's this guy's fault. Go ahead.
Okay, on page 8.
Get that microphone over there, Joan.
Oh. On page 8, look at page 8. Page 8 of 12.
Oh.
Read that. After consulting with the new owners, they have decided they would love to provide him with missing continuing education certificates backdated as a measure of good faith. We hope he'll, you see that sentence there? Believe that he has purchased and completed his continuing education during the hectic transition in 2019. That help clarify anything?
Yeah, I guess I'm just wondering what are you asking us to do to let him have his active license back? Is that correct?
I'm just presenting what he has requested.
What is he asking? What is he
He's
requesting?
asking that the commission honor what D&D has said that he did it, and what he is saying that he did it, and that this was a result of a reporting error.
Okay, I'd like to make a motion that we accept this request.
I've got a motion by Ms. Frank, seconded by Mr. Ferris, that the request of Mr. Barnes be honored and his license with the materials supplied by D&D be declared active. And he's got a form. I mean, it will be active through December of this year, right, Caitlin? I mean, that it doesn't start 2 years from right now.
No, yeah, it would just go back.
Okay, so he's got to get through this education renewal as well. Jeff?
So, Caitlin, Ross, the information that D&D has provided to you, you trust that information, you believe it, you have any reason to question it from D&D's perspective?
Trust that information.
Other questions? The motion on the floor is to grant Mr. Barnes' request. If you're in favor of that motion, please vote aye.
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 If you're opposed, vote no. And that motion passes. Thank you, Caitlin. Thanks, Commission. Let's go on to Mr. Johnson.
Okay, this one is similar to the first one, where this licensee, their E&O was suspended, and the penalty that they are asking for a waiver from is for failure to maintain E&O. And he obtained E&O as of August 4th, 2021, and also supplied a letter to the commission and a note of some of his additional medical reasoning.
So his is from his insurance company and not a doctor. Is that correct?
So I don't know if you read his letter, but his reasoning is it's not his personal health. Well,
All right, Commissioner, thoughts? So if the commission always has the latitude to approve the request, modify the request, deny the request, but let's get something on the table so we can discuss it.
I make a motion.
Okay, motion by Ms. Torbett, second by Ms. Franks, that the request of Mr. Johnson be approved. Discussion. All right, then, if you're in favor of that motion, please vote aye.
Aye.
If you're opposed, vote no, and that motion passes. Thank you. Now, Mr. Buchek, not sure that's how you
actually Janice,
actually what?
Miss Buchek.
Oh, miss, excuse me.
Similar situation as well. A waiver for the E&O penalty. License was suspended in January. E&O, I believe, let me confirm, what was attained around a similar time recently. And there's a letter with family health issues.
Motion by Ms.
Motion
Torbett,
to
second
approve.
by Ms. Franks, that the request be granted. Discussion.
Oh, it is in place now.
Yes, let me just, I'll confirm that, the actual date.
And the education.
License and retirement.
Who has to do the?
Bring it back.
To get it
She's
out.
not expired yet. Her license is good until September of 2021. She does not have the E&O yet. So this would be a penalty in allowing her to just put her license into retirement.
She wants the penalty waived. Retirement.
Essentially, yes.
Can't retire until that penalty's taken care of, right?
Unless it's waived.
Okay.
Yeah.
That penalty is 700.
Yes.
700. The penalty is 700 for what?
So, in the law and in the rule, it breaks down how long you've been suspended for E&O. And so if your license has been suspended for E&O for 120 days, it's $200 if you backdate the policy, and then it's $400 if you do not backdate and you have a lapse in coverage. And after that 120 days, it goes up to $500, and then it goes up an additional $100 a month during that suspension, up until a year, at which time, if your license has been suspended for E&O for a year, it would then go into a revoked status. And at that point, you would have to retest. And
So that fee goes to the Real Estate Commission, correct?
yes, I believe the fee probably goes, I'm not sure the exact, but I'm sure it would go into our compliance.
So what's the cost? I'm just trying to get a sense as what the penalty is vis-a-vis what's the cost of the insurance. It's about the same? Is that
The state insurance policy, I believe, the one that is under our contract, I believe is around $225 for 2 years.
She hasn't been practicing real estate. From what I understand, she didn't do any transactions in this period anyway.
That's what yes, that's what's in her letter.
Okay, so the motion is to waive the fee with the intent that the licensee can retire her license.
Okay, look.
Yes.
So if the fee is waived today, do you have a request waiting for this result to retire her license?
Even if the fee was waived, she wouldn't go back to an active status until she supplied the policy or supplied the retired form. So let me see if she submitted it. I don't know if she was waiting to see.
That for both things, not one or the other, but both things, right?
Got to show she has insurance, and then she's got to request retirement.
So we have been allowing individuals, if they would just like to go into retirement, because there is no E&O required when you're in retirement, to not buy a policy to then go into retirement. And so they would either have to comply with the penalty, or if you waive the penalty, she would still have to supply the retired form to go into any other status other than active, retired, or suspended. We wouldn't put her to active without the E&O. That makes sense.
Either proof of E&O, or she has to provide proof of E&O to stay active, or she has to submit the form.
Correct.
Question, Caitlin, what percentage, do you have a sense as to the number of licensees who go ahead and pay the fee and move on down the road when they let their E&O lapse? In other words, is this request we're getting today, is it 1 out of 1, or is it 1 out of 50, or I'm just trying to...
Well, you got 3 today.
3, okay, so we got... Is that 100% of the people,
no,
or is it...
No.
So
I could give you that number. I don't necessarily have that number. I know, so when we actually did the suspension on January 29th, I'd have to really think about memory, but I want to say it was suspending around 1,000 to 2,000 licensees. But I don't know that the number off the top of my head. But once you're suspended, you have 30 days to
Correct.
become compliant with no penalty. And so
we notify them?
Yes, we notify
writing?
them via letter. By law, we're required to send a letter to their home, to their firm, and then the PB also gets a letter. We also did a My Emma mailing prior. If you were showing that you were going to be suspended, we sent out an email to those individuals prior to the suspension. And then Rice, as our contracted provider, is also required to send at least one notice via mail. And so I want to say around October or November, they mailed to all licensees the terms of our contract with Rice and how you could renew your policy through them. And then I believe they also sent some additional emails.
So, and this is maybe just a comment, but I mean, if you have insurance on your home and you let it lapse, you have no insurance. I mean, things happen in life, and I'm a sympathetic person, but that fee is set up to incentivize people not to let this happen, correct? In theory.
Well, it's in the law.
Deterrent.
Yes, it's a deterrent. So if things happen, you miss it, you've got notice, you've got time, and you've allowed this thing to ramp up to $700 because of issues. I don't know. It seems like, I mean, the person has nothing to lose by coming to ask us, to waive the $700. So all we do is say no, and she pays the $700, and everything's square, right? Theoretically.
Well, in order to become active, she would have to pay the $700,
right?
Or retire.
Okay.
Well, yes.
So
she can't retire though currently unless the commission waives the fee or she pays.
For instance, Steve, in Caitlin's report, there's a little line item on licenses that talks about suspended licenses.
Right.
And I think it's 1,100 plus or minus right now, Caitlin, somewhere in there.
Suspended
up
for
my
a variety of reasons,
But
though, right?
primarily errors and omissions.
Yeah.
And the suspension runs on a monthly basis because not everybody's policy is a 1/1/2021 policy. So you'll see that number fluctuate, and it's not necessarily people that have been suspended for 7 months. It's
Right.
constantly.
This one's a pretty high number, correct? As
Yes, because
penalties go.
the 3 that you have seen today, were all January suspensions. And I mean, primarily, I want to say roughly 80% of our licensees all renew their E&O and expire on the same January 1st cycle.
We've got on the agenda, last item on the agenda today, to talk some more about E&O, especially group policies. So keep thinking.
Okay.
We'll get back to it. Yes, Jeff.
So Jan Busek, or Buchek, is not the same as the Jan Albertine in the letter from the doctor, or the Janice.
So I believe she said it's her mother.
I can just say, as someone who has dealt with an ill parent, I can totally understand how this would be the last thing on someone's mind, especially if they were practicing real estate actively anyway. So I have a lot of sympathy for situations such as this.
I have a question. So if we waive the fee and she goes into retirement, what does she have to do to become active at that point?
So depending on, so you have to have E&O and you have to have firm affiliation. And then we look at the individual's education. And if you have been in retirement to where you've missed an education cycle, then you would have to do 16 hours prior to coming out. So, if you were in a retired status for multiple renewal cycles, then you would do the 16 hours. If you went into retirement one renewal cycle and out within that same cycle and never missed any education, then you wouldn't have to do it. Does that make sense?
Years ago, the commission required you to have your education current before you went into retirement, and it became pretty obvious it made more sense for it to be current when you come out rather than when you go in.
Yeah, it still has to be current. You cannot go into retired in any other status other than active. But we, rather than having them just do an extra 16 hours before going into retirement, we look to see if they missed a 16-hour cycle before coming out and becoming active.
I'll make a motion to approve this.
We already have a
It's on the
motion.
floor.
What?
It's
We
made
have a motion on the floor.
Stacy.
You can call for the vote.
Yeah, call for the question. The
Call the
motion.
question.
There's a call for the question. Those in favor of the motion to grant this waiver, please vote aye.
Aye.
Those opposed, no. That motion passes unanimously. Ross White,
Mr. Chairman.
education report.
All right. Mr. Chairman, members of the commission, call your attention to the Tennessee Real Estate Commission education agenda for August 11th, today, 2021. I present to you all of the providers, instructors, and courses signified by A1 through A17, and I believe they comport with the rules and regulations. I submit them for your approval today.
It's your recommendation we approve courses A1 through A17.
Yes, sir.
Is there such a motion? Mr. Diaz makes a motion to approve. Ms. Frank seconds that motion. Is there discussion on any particular course? If not, let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously. And no new instructors this month.
For this month, Mr. Chairman, members of the commission, there's no new instructors that went along with these, so they're all approved or previously approved.
Just a quick question for you. So I kind of perhaps went off on the Tennessee Realtors last month a little bit about them wanting us to come up with something to satisfy their membership. Have you heard back from them at all about synchronous courses or Orello approved courses? I was a little bit.
I have had some correspondence about, I guess, the issue of the cost, but I haven't, and then I responded that being a part of Arello and being on the education committees, just right now we're conducting some things that are improving the synchronous courses and the certification of those courses. And there's some updates and things that Arello's working on. So outside of that, that's all I've had.
I do know that at a TR meeting that their lead attorney mentioned that if the possibility of them lobbying our legislature to take that Arello requirement off. So
I just felt like they were trying to put it on our table to handle, and I want to keep it on their table to make a suggestion to us. And I think the minutes accurately reflected that. Anything else, Mr. White?
That's all, Mr. Chairman.
Appreciate your work. Thank you.
Thank you.
Okay, Caitlin, you're officially now, you have a report.
Yes. I just have a couple updates for the commission. I just wanted to mention we are going forward with the October meeting in the Tri-Cities, and it will likely only be a one-day meeting, and will be on Thursday. Let me get you the exact date. I'll follow up with hotel information and those details. But the meeting is on October 14th, coming in on October 13th. If anyone cannot attend, please let me know as soon as possible, because we are looking at the room block. And then in addition...
When you say Tri-Cities, which city do you mean?
Well, we were talking about this last night because I think technically where the meeting room is in a different, but all very close. Then
You're staying.
Yes, and I believe last time we stayed in Gray, and the meeting was in Kingsport. So I believe we're staying in Johnson City, and the meeting is in Kingsport.
Oh, Caitlin, it's possible maybe a commissioner from West Tennessee might need to stay a second night, would prefer to stay a second night. Is that an option for somebody traveling 600 miles?
It would be, but they would ideally let me know in advance. So I guess I can't already predict whether it's going to be a long meeting or a short meeting, but I don't have any reason to believe that it would be a longer meeting than normal. So just keep that in mind when you're thinking travel.
What was your prediction about this meeting? Did you think
Long
it
or
was going to be a long
short?
meeting or a short one?
I think this is going to be a normal length.
Oh, thank you. Good answer.
Start doing over under.
Yeah.
The meetings this year have been as efficient as possible, so
The staff is so efficient.
I don't know if it was that or the commission.
And the consent agenda and the way that they have been written well for us, that's been a huge difference in our time.
Well, that's all legal.
I know, and we appreciate it.
And then I just have two other things to mention, and one I might even show you guys if you would like. The second is there is one more position available for Arello in Orlando if anybody would like to attend. It is September 15th through the 19th. And we have gotten approval for 2 commissioners to go. Steve will be going, as well as Marcia as president, and then Ross as well. So if there's anybody else interested, please let me know, and we can get you all set up. The last thing which I can show you is...
Mark.
Yes.
Let me encourage anyone to please attend those meetings. They're really worthwhile, informative. And please, if you can go while Marcia is chairman of that Arello, I encourage you to go. It is really worthwhile.
I thought she was queen.
She is queen.
Oh, I am the queen in my own mind.
She is the queen, and if you can at all go, please do. The other thing that I want to say is Commissioner College. I was really impressed with what they had to say, and I want to do that. And also, if you can go, they have a one-day class for each one of the conferences, and they'll have one this in September, and then they'll have the next one in the spring. So if you can go and take one of those classes, I think it would be really worthwhile.
And if you can't go, the Commissioner College is now online.
Yeah.
So if that's something you might be interested in, but you can't go, that's available. And then I think she's got something. I will say this, it will be in Nashville next year. We've booked the hotel already. It's the Lowe's Vanderbilt. So just gear up. We're going to all need to be at that meeting, please.
Oh,
I need to go.
No. I just wanted to show the commission. I know over the years there has been request for an improved public search or an improvement to verify. And that is now live. Well, I do want to preface this by saying I still don't think this is exactly, this isn't going to be perfect to exactly what real estate wants, because this is for the whole department. But I do think some of the commission's request and needs have been met with this new system. Our admin manager and other staff have been testing this for us. So obviously let me know, it's still a work in progress. So if you see something, you can let me know. I can't make any guarantees that it will be changed or improved. But this you will get to from your licensing page. So it's at core.tn.gov. So essentially everything is moving to core.tn.gov. So that's where you can renew your license. That's where you can file a complaint. And then also now that's where you do public search. So I was just going to quickly show kind of two ways to do this search. So, John, do you mind if I use you as an example?
Education.
Okay, and I was playing around with this earlier. So sometimes we obviously know that's John's name, and so it's no problem to search him this way. But if you're not exactly sure of somebody's name, sometimes it's best to do kind of less is more, maybe only put in their last name, because a lot of people have nicknames and their name is kind of not exactly as you may think it is. And then make sure you allow the CAPTCHA to load. And then from here, this is the error I had earlier.
Like a waiver.
We'll give you one today.
There he is.
So long. So I think what the commission will like more than this page is probably the firm license page. But here you can now see, okay, you can see that John is grandfathered. He's a principal broker. He was first licensed in 1981. He's got an expiration date of 2022. Active status. Down here you can see the firm affiliation, and then you can also see all education.
If he were not the principal broker, would it have the person's principal broker on there?
So we can test that with somebody else. What I can tell you, I was actually going to pull up your firm, Marcia. Under the firm, you can now see who the principal broker is, and you can also see the affiliated licensees. And so that to do that, you would go by search by business. So here you can see where the firm is located, and then under this section you can see that Marcia is the principal broker when her license expires, and then the firm affiliation is broken down by affiliate brokers and then by brokers. So here you can see who's affiliated with Marcia's firm. And then this is actually the date that they were added to your firm. So the date that we received the Trek 1. And then you can see this is the grouping of people that have their license as a broker. And then they are working to add disciplinary action for the firm under this section as well. So phone number, we don't have that on there now. We might be able to add that. So let's just pull that one up. Is that right? Okay. So this is probably going to pull a large, okay, not as much. I will say if you don't have that, I could imagine that it would be harder just because a lot of people will do, you know, like Nashville, whatever, and then they'll do the DBA as Cry-like.
Williams has
A lot of DBAs. So I do think not knowing as much information could be hard on some of those ones that have a DBA or and I would imagine that some of them are probably like Memphis sales DBA Cry-like. So
doesn't show me the Nashville or the Brentwood or the Franklin office. How would I know which one? I need to click on all of them?
currently you would. Let me go back though, because again, I'm still sort of testing this, but there are other ways to search. I have it searched just by business, but you can do it by city, or you can also, like, if you, when I was searching, I'm searching for anybody under that name, so you might get, obviously with Cry-like you wouldn't, but if you just searched, you know, if I just searched Franklin, I could get construction companies. So you also have the option to search just under real estate firms by city or by county. Yeah. So again, if you see something and you want it added, you can potentially let me know, and I can just see what the options are.
Fabulous. Took 7 years that I know of to get that done. 9 years that you know of.
Good things take time.
Okay. Thank you, Caitlin. What else in your report?
That is it for my report, unless anybody has a question for me.
We'll reserve the right to ask you questions just right out of the blue related to your occupation. All right, commissioners, it's come to my attention that Martin Green, who just keeps looking different every time I see him, but maybe because it's in person now, I don't know, is here to talk about our last topic of the day. And with him is Tony. And Tony, I don't recall your last name, but two attorneys here wanted to talk about this group or firm group E&O policies. Is that correct, Mark? Who's taking the lead on this? Push that button, Mark.
Good to see everybody. Hope y'all are having a nice summer and staying cool. I think today's going to be the hottest we've had in quite a while. But anyway, this topic, I got involved in a conversation during our E&O disciplinary actions this year, and it has to do with, like you said, Mr. Chairman, group policies versus individual policies. And I'm not 100% certain that I understand the clarification and the opinion of the commission as to the difference. We have people that have group policies that cover an entire firm. And if a person is an independent contractor or an employee of that firm, they are covered, it appears, under the terms of that policy. However, their name is not listed in the policy. So the question then becomes, is if the principal broker provides a list of the people covered under that policy, is that a sufficient coverage versus each individual having their own individual policy? And so I wanted to bring that before you today to discuss or to give any opinion or guidance on what you think. I will also ask Tony and Pam, who we have been talking about this to some extent, to add additional information that I may have missed. But that's the overriding umbrella issue as we have come across it over the past few weeks.
If you want to start this discussion.
Sure. I guess the question I have is, you just said that the broker is providing you a list of their agents, and then they are stipulating that those agents are covered by their group policy. Is that?
That's. Go ahead.
So that has been the case on occasional. Tony Glandorf, I'm the Chief Counsel here for Department of Commerce and Insurance. Glad to be with you all here this morning. To your question, Mr. Diaz, we do have some policies where they do not state on the front the actual names of the affiliates within that firm. However, they have attached some things such as a letter that says these are the persons that are actually covered. We have that on occasion. On other occasions, we have nothing. It just shows the accord form on the front, which is probably the more difficult issue. It says that it covers this real estate firm, and we get the accord form, which we would say you don't have affiliate coverage, to which the response is my actual policy says that I do, which we don't have. So then when you receive the policy, there's a box for the named insured. There's a definition in the policy for the named insured. The named insured definition is not standard within the industry. It's not required to be standard, so you have to look at the policy. Some of those policies do say that they cover all affiliates and independent contractors. So the principal broker says, there you go. During that period, all of my affiliates were covered, to which the question is, who is that? So if you can see kind of the circular conversations we're having, for those instances where they would be covered under the policy, what is the commission's will on the type of information that we need to tell them is required to be submitted with that form? And is that acceptable to you all that they are as affiliates or independent contractors under that named insured or additional insured? Is that sufficient for you all, or do you all require an individual policy in the individual's name and will not accept a group policy?
Common practice, I guess, if a principal broker or a firm is going to cover its affiliates, that the principal broker or the firm would have some kind of fee assessed to those affiliates to pay for their part of their coverage.
It depends on the company.
Contractors. So, Tony, you and Mark have taken a look at the statute, right? Does it give you any direction on how we should interpret this?
It's statute or rule? Statute. Okay, thank you. I can visually see it in my head. So it says that each affiliate is required to have an individual policy, and then the next section down says, in addition to the individual coverage, a firm may have a group policy, a firm policy. And the way that I read that statute when I was speaking with Anna, because the Real Estate Commission is not a commission for which I've been given legal advice for the entirety that I've been here. The first time I read it, I said, oh, what allows for group policies? And then when I was checking with Anna and the rest, it seems like, oh, that traditionally hasn't been the thought. The thought was that you had, or the interpretation was that you had to have had individual policies. And so we ran into a situation where it seems that two reasonable minds could have different opinions. And so we have seen it out in the industry, who probably is why we're running into this issue. And so based on my reading of it, I'm not sure what the traditional approach of the commission has been, but I wanted to bring it, we wanted to bring it to you all so that you all can look at this issue, because it may be something of an instance that group policies may be getting more and more popular with the firms as opposed to when this statute was written. But the way that I looked at it, I believe I could have read it both ways, that it would allow for an affiliate to be individually covered under a group policy. The question is, how does the Real Estate Commission know that they're covered?
I just wanted to chime in. Do you guys have your green books? Or red books, either way. They're very similar. So in the green book, it's page 18, 62, 13, 112, and Tony is referencing A and B. So if you wanted to follow along. 60
in the red book.
Yeah.
So just logistically, have companies with group policies notified the commission when, say, an agent leaves their firm?
Joins.
Is that what happens now? I mean, how do we know it?
Yeah, so it seems like
They get a trick form, or it's online.
Question.
We do get, I don't think we get every single firm letting us know that the person, we get the Trek One form. In some instances, we get forms letting us know that coverage is no longer in place.
So
but not in every instance.
Assume that when some group policy, they're no longer insured at that point.
you leave a firm. Yeah.
I think, yes, that's the issue that's a secondary issue, Chairman Grease, that we run into, is that if that group policy would cover all those affiliates for a year period, and one of those affiliates does leave the firm, and that was the only coverage they had, then they would automatically drop from that coverage because they're no longer affiliated with that firm. So that becomes an ancillary issue of how do we know who's been covered on what period, because they may go to a second firm that has a similar type policy, and they would be, covered under that one. But in the instance where they went to another firm and they don't have a group policy, then they would receive their own independent. Then that would require 2 documents to ensure that that person was covered for the entire period, which was the first group policy with the affiliates named, and then their second policy that they would have gotten themselves when they changed firms.
Doesn't the policy itself have to, I don't know how the insurance company protects themselves when they write a policy on a group, they got to know who's in the group. And there's got to be a list of, because if they had a claim, how are they going to protect themselves? Oh, that person was in the group or was not in the group. So there's got to be some kind of an accounting or list or something between the firm and the insurance company. It would seem to me like, otherwise a group is not defined other than the group being that firm's group, but who's in the group on the day an event happens? How do they know?
Right. Yes. So it's my understanding, because I had some conversations with some of our experts upstairs on insurance policies, since we regulate that industry, not within our division. And then I've actually called one of the insurance companies to check on a policy, and they actually did not have a list. It actually did cover all affiliates that would have been all affiliates that were part of real estate transactions with that firm. It covered them, but they did not have an individual list of those persons. It would have been, this would be an easier conversation to have had there been, if there was an actual underlying list of those things, because I brought up some of the same issues that you brought up. How do you know that one of those persons doesn't have a prior claim against them for something like that? Would they have been a higher, would their policy would not have been at a higher rate? So, but that is not standard within the industry. I think that's the best way I can capture that. To your question, that is not standard within the industry.
And then the other thing too are the riders. Like, are you doing new home construction? You need an extra rider. Are you doing property management? You need an extra rider. So, and these companies who are doing these big groups, they are big companies mostly that are doing it. So it sounds like to me that we need to come up with a set of criteria that everybody goes by, and this is what's needed, and you can pick your insurance wherever you want it, but it has to meet these certain criterias, including a list of people who are on this insurance. And when they move, I think that would trigger track to see, well, okay, they're now off of this group policy. But without the names, you wouldn't be able to do that.
I think we would need to require like them letting us know to end the coverage. Like that would need to be an additional, because right now we get the Trek 1 form and the
Doesn't
current
say anything about insurance.
nothing but insurance, and the current process doesn't have staff going to look at their insurance to see, okay, are they on an individual policy? Are they on a group policy? And administratively, you can't always tell that it's a group policy over an individual policy. We know our big insurance carriers are individual, but we wouldn't necessarily know just by looking at the policy number and the effective dates that it was a group versus.
So we need that information. If we're gonna be policing that, then we need to know. They need to know what's required. And here's the list of what you've got to do to meet the requirements. And then we have to figure out a way to make that work.
Vice Chairman Franks, I think you brought up a good point, a discussion there, which is my second note here, which was if the commission is willing to accept group policy that does cover affiliates of the firm or whatnot, I believe how we get those names was the second question, because we've gotten them several different ways. When there's not many affiliates, and correct me if I'm wrong, Caitlin, but I think less than 5, oftentimes they have sufficient space on the Accord form to list those. It's when it goes over that they do not have that space, and as I said, it's not standard. But the two ways that we've seen it: should the names come from the insurance company as to who's covered under that policy, or would the commission be willing to accept those names of those affiliates from the principal broker under the guise of they're responsible for ensuring that they have that policy, and if there is ever a instance in the future where the policy was denied by the insurance company saying that it didn't cover that person, that would be a complaint against the principal broker. I think the difference between the two is flexibility and compliance. Is that I think it's been easier for the principal brokers to send the list than to go back to the insurance company and get that list provided to them. I actually did call an insurance company, said, could you give me a list if we had that? They said, no, I can only give it to the principal broker.
And so if the principal broker is the one in charge of it, I feel like they should be the one providing the list and not leaving it to some third party that may have a mistake. And then the principal broker, how can we hold them responsible when a third party made the mistake? So I think it needs to come from the principal broker.
I was just going to chime in. Administratively, we kind of set that number of 5 because with like the Accord form, our staff has to individually add it to each licensee, and when we get it on a spreadsheet, it can all be uploaded at once into our system. So from a processing standpoint, if somebody has over 5 agents in their firm, we can add them all at once, assuming the information is correct, their name is correct, and their license number is correct. We can add it all at once. So that's part of the reason why we have done it that way, asking for it on a spreadsheet, is because it allows for essentially no processing.
So instead of asking, we can require it.
The problem is the list changes daily, and mostly in today's you've got how many agents coming in monthly? New agents and
Five.
Well, we have a lot of transfers. I think transfers is really the is where the group policy and whether somebody's covered would come into play. If they transfer to a new firm, they may no longer be covered under that group policy that's currently on their license.
So,
But it should be good for a year, I would think. Or does that drop them off? Does the insurance company drop them off?
I don't know. I'm just thinking we get, you are now at Franklin Realtors, you want to move, we get the transfer, you were covered under the group policy there, you transfer to a new firm, they have their own
That's correct, Caitlin. Vice Chairman Franks, because it covers that firms and the firm's interactions with the sale of real estate, the additional are its affiliates. So it's not going to cover if that affiliate leaves a transaction under a different firm, because that's the group policy. That is, Caitlin's bringing up a very good point of the difficulty of persons dropping in and out of those policies, and and how we would be able all together keep track of those.
So Caitlin, when an agent transfers, they have 10 days to to hang their license with a new firm, and then.
Yeah, I think there's a rule that speaks to broker release. If you've been broker released, you essentially have, by rule, you have 10 days to transfer your license or to put your license in another status, such as retired.
Question.
They also have that same 10-day period to obtain E&O insurance individually or to be covered under.
That is not specifically stated in the rule. The E&O rules say each licensee is required under this chapter as a condition to licensing to carry E&O. So it speaks to it in a different manner, but it's not necessarily, that's not in the rule with like transferring.
The insurance company would sell an individual policy along with a group policy because they're capitalists and they want to make money. So an agent could be covered individually and be a member of a group.
Right. Okay. And historically, that's kind of been an issue too, why we have to know who's covered under the policy, because not every agent at a firm may choose to go under the group policy. They might choose to also get their individual coverage, or maybe they were previously at a firm where the individual coverage was required, so they have that and it's good for 2 years, but then now they're also covered under their new firm's group policy.
Like with the riders.
If you added a line on the TREC form that just defined where they, when they're leaving, where they have E&O, and as they're going to the new firm where they're picking up E&O, it would help you a lot, right?
Yeah, I think we'd have to ask, are you covered under an individual insurance policy? Are you covered under a group policy? What is your, if under a group policy, what is your new policy?
That was so small.
Way to go, Joe. So, Steve,
I think my question. I think my question was answered just in this last little exchange. I was just wondering where the group the language in the group insurance says that we cover agents that are employed at the time of the event, so that you don't have to worry about in and outs. You got a blanket coverage. So if you're employed at Cry-like, if you're there and you make a mistake, we're covering you. Does it say that, or is it?
No, that's how it would apply, is that it's going to apply to this time period. So if you were a part of a real estate transaction that happened in July of 2000, and that policy was from 2000 to 2001, if you then left that firm directly after, that policy is still going to cover during that time period, that interaction, for whatever the, into the future, however far until, claims can't arise anymore, during that time period is set. And for those agents that would be there would be set. To your point of employees, that's one thing that we would have to look at those policies, that if it only covers quote unquote employees, those are traditional, W-2 employees, not 1099s. And so we would have to go back and have them tell us, yes, that those are actual employees, because that's a minor difference within the policy that the principal broker just may not be aware of, is that they would think that it would cover their affiliates, but it would not. Because I was very surprised that it would actually cover affiliates and independent contractors. And when we had the personnel and insurance division upstairs review that, they said, yes, it does, it would cover those independent contractors and affiliates. That's what it says. They also did say best practice would make sure that they have individual listed names. Because the insurance companies are very good at finding ways of denying claims.
Does the insurance company on the accord or in the policy define affiliate? Because words have meaning.
No.
So,
Does
because
not.
affiliate in the real estate business might have a different meaning than an affiliate in other businesses.
Right. It does not. That was one of those precise reasons why they said it would be best that they have the list of the individuals that actually are covered.
So yeah, so when you say affiliates and vendors and contractors, are not, in that context, affiliate might have a different definition.
To that point, I did the one insurance company that I did call on a policy that said affiliates. I asked them, "Do you cover the real estate affiliate brokers?" And they said yes. We were going to cover them and any other person they were affiliated with in a real estate transaction sale.
And every state has different names for those licenses.
So if an affiliate, they'd also include independent contractors, because sometimes affiliates are independent contractors.
I could only say that it could. Whether it's going to or not, that would be.
So, are there other commissions inside the department that have licensees who have to purchase errors and omissions insurance?
You do.
Home inspectors.
So, is that the only one?
I don't know if it's the only one, but it's one of my programs. Oh, and auctioneers.
It just seems to me that it's an appropriate time to talk about this, because the group policy, the state's approved group policy, we're not halfway through the term. But it seems to me there must be other commissions that do this. It seems to me Arello might have information from other states that could be helpful. It seems to me that Cindy at Rice Insurance might say, well, here's something you need to think about in this particular case, because she ought to know how to handle that objection when it shows up. Can we research this a little bit?
It's got 26 states.
We can. So I do know from Murillo, most states, we are unique, but most states either require the E&O insurance or they have the education and recovery account. It's not as common for states to have both. I think Cindy is going, not to say she would have a biased opinion, but her opinion is going to be from
an insurance
provider. And from Rice. And I do believe, I'll defer to legal, but I believe the law requires that any other policy you can obtain, but it must meet the minimum standards.
I just think that somewhere, some entity, a state or a commission, an insurance company is tackling this problem.
We can ask that question.
And Joe's simple answer, which was my kind of answer, by the way, Joe, of just putting one more line on the Trek 1 form might be the solution. I don't know, but I think with a little more study on it, we ought to be able to figure out how to help staff and legal.
I think one of the issues that we encounter at affiliates and principal brokers and firms. So in my programs where they have errors and omissions insurance or general liability, it's for one person. Like, we don't license home inspector companies. And since we have like multiple layers of those, it creates an additional kind of issue, which would lead to their question.
You can't be the only entity that got this issue and try.
I think the line helps in the sense of they know they're leaving a group policy and they got 10 days to do it. And when they come back and go, I didn't know what I signed. We're like, well, you signed it. So it's, I think if there's a box on there that says you had a group policy, you're not on that group policy anymore, you better figure something out.
Right. And that makes sense, but some people won't leave. Does that make sense? And we may not get that form from some individuals unless they transfer.
I hate for Tony and I to run out, but we've got another meeting we've got to get to, Mr. Chairman. So we will do further research on this, but we did want to bring it to your attention and get a conversation going with the commission regarding this. So we will be prepared to discuss again next meeting. So thank you, and let us know if we can do anything for you.
And Mark, Caitlin can ask other Arello administrators in all the other states, what are they doing? And so that might help with the conversation too.
Okay, great. Appreciate it.
Thanks, man.
Thank you.
All right, let's get back to the agenda, the legal agenda, the consent agenda. I know. All right. You've received two documents. One is a list of the cases 1 through 59, identified by case number. Do we need to, Caitlin, I've forgotten, do we need to approve that list? Or
Approve the listing and then pull out the ones that you would like to discuss.
Okay, let me restate it. So you have a list initially identified by case number of 59 cases and recommendations for each case from legal. And so I would like to entertain a motion to accept council's recommendation on cases 1 through 59 with the exception of cases 5, 11, 18, 20, 23, 26, 34, 46, and 50. Now, before I look for that motion, does anybody have any other cases they would like it taken out?
54.
54, okay.
I would like to recuse myself from case number 38 and 39.
Okay, we'll let the record reflect that. Okay, with those additions, is there a motion to accept council's recommendation?
So moved.
Second.
Okay, council's recommendation on cases 1 through 59 with the exception of the cases we've just listed. Mr. Diaz makes the motion. Mr. Bagley seconds that motion. Discussion. Let's vote. Those in favor of that motion vote aye.
Aye.
Those opposed, no. The motion passes. Let's go to case number 5. On the record or off? We'll take a minute. We'll wait to get back. Hey, Dennis, in the meantime, would you like to tell these commissioners who don't know you a little bit about your history?
Sure. Dennis Gregory. I've been here with the department since 2015, and probably, I guess, about 6 months into that, was a disciplinary counsel for track for about a year, I guess, close to a year. And then since that time, I've been doing largely contractors board and collection service, and now pretty much exclusively just contractors. So due to a shift in manpower, Ms. Brown departing in the last couple of months, been brought in maybe just temporarily to do much the same as what I was doing before, just with different faces. I think during one of the breaks, I was telling Mr. Grease and Ms. Franks that I think they may be the only two that I remember, the only two that were here when I was still doing this. So,
well, you also have a second job.
Yes. And part of that time, I've been with the department since 15, but I think since 2015, I've deployed twice as a member of the Army Reserve. So while I have been here on paper, I've been in body, I've been other places. So,
like where? So,
thank you for your service.
What desert were you in?
Say again.
So when you deployed, where did you go?
Well, the 2017 was a mixture of mainly Kuwait, and some part of that was broken up in Afghanistan, and then this last time was purely just in Kuwait with the COVID protocols. Intra-theater travel was kind of limited unless you had a real good reason to go somewhere. Actually, Tony and I, we passed each other somewhere along the way, but didn't get to physically see each other. But I think as he was leaving, I was getting there.
Okay, Anna.
Okay, there was a couple differences that I think just two. We should have 5, 11, 14, 18, 23, 26, 27, 46, 49, 50, and 54.
Too quick.
Yeah.
Sorry. Okay, where should I go back?
Let's go. So 5 and 11.
Do you want me to just call them out as we go?
Well, I want to make sure the motion.
Okay.
5, 11, 14. Who's is 14?
So 14 is Diaz.
Okay.
18 Franks. 23 Grease. 26.
Wait a minute. What about 20? Take it off.
Yes, I think we somehow 14 wasn't included and 20 was. Okay. 23 Grease, 26 Grease, 27 and
I took it off.
you took it off. Okay. It is on Jeff's list.
Oh, that's a 700 miles. Electricity was 700 miles.
Right. Yeah. Yeah.
You want to keep that on?
I have a different issue with that.
Okay,
Yeah.
well, let's keep 27 on then.
Okay. 27 now pulled by Diaz, 46 Grease,
34 gone.
34 gone, 49 Diaz, 50 Grease, 54 Diaz.
Okay, so let's go back and visit the original motion on the calendar, the consent calendar. So, by common consent, we're going to withdraw that last vote, unless somebody wants to object to it, and instead look for a motion to approve legal's recommendation on cases 1 through 59, with the exception of 5, 11, 14, 18, 23, 26, 27, 46, 49, 50, and 54. And we want to make sure that the record reflects that Mr. Bagley recused himself on cases 38 and 39. Now, can I get a motion to that?
Wait.
So moved.
Thanks. Steve, you can. Let me just get this on
Second.
record. Okay, and Stacy seconds it now. Marcia.
Okay, I just read my number 5 that I had wanted to take off, and I had an enlightenment moment, and I'm okay with it the way it is. So take 5 off. I'm okay with the chickens.
Indoor, outdoor chickens, household chickens. Okay, everybody understand the motion? Okay, we're going to vote on that motion. Let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no, and that motion passes. Now we're to case number 11. And I forgot, is that mine?
That's mine.
Jeff, okay.
All right. So I just had an issue with the fate of the earnest money. A sheriff doesn't have any authority to tell a broker what to do with their earnest money. Is that correct?
Right, and I apologize. I got so outdone with both these parties that I just sort of pulled a lot of their information into the complaint and actually quoted a lot of it. And then when I looked back on it a couple of days ago, I remember it. Well, not remember. I just then realized that I had sort of left the earnest money, or as you put it, the fate of the earnest money out. So no, that's fair enough that we talk about that now. And I would agree with you. I don't know, and I've even attempted to contact this broker and have, without any success, to get a little more information. Normally, we don't contact the parties unless there is some need or if there's an investigation. We make contact with them that way. But I was not able to get any more information about where the earnest money went to, and why the local law enforcement was really involved at all.
Right. So the record doesn't tell you whether the earnest money was dispersed.
It seems
based on a reasonable interpretation of the contract or
no
interplay?
contract attached. It was just merely just the crux of the although the complaint's not very well written, but the crux of the complaint seems to be I didn't get the $1,000 earnest money back, which is, I think, when you read it all from start to finish, yeah, that's probably what the issue is. But then the respondent says, well, we kept it because local law enforcement said we needed to. So normally in a situation where, well, any situation where the earnest money is kept is usually where the buyer has decided to not purchase the
Well,
property.
I mean, the broker holding the earnest money has to disperse it
Right.
somehow.
So that's where we're at on this, and unfortunately,
And it's been longer than 21 days, I'm guessing.
it has.
All right, so I'm going to make a motion. Council, please insert the appropriate statute that we assess a civil penalty of $1,000 for failure to disperse earnest money.
Second. Offutt seconds that motion. Discussion.
Weren't they in possession of this earnest money?
I think
the
that's
sheriff.
I think both parties admit that they were. And in fact, as I recall, there's a copy of the check in the complaint file. So I don't think there's any question about that. In fact, they did have it, they being the respondent.
You've heard the motion. It's to offer a $1,000 civil penalty for failing to disperse in a timely fashion. If you're in favor of that motion, please vote aye.
Aye.
Aye. Opposed, no. That motion passes unanimously. 14. Jeff, is that you as well?
This is your recommendation is a civil penalty for failure to respond, and I'm fine with that. I wonder if we could go a little bit further and maybe suspend the firm's license and amend the recommendation. I just think, if they're not able to do business under a license and they get notified that their licenses are suspended, they'd be more likely to figure out what's going on. So I'll move that we amend council's recommendation to suspend the firm's license.
So in this case, this is a failure. At this moment, it's a failure to respond to complaints, correct? And Jeff is suggesting that to further get their attention, we also suspend the firm's license.
Sorry, I misspoke.
And that's why I pulled number 5 off, is because if they've not responded, I don't know how we charge them with something else when they've not responded. That's why I pulled number 5 off.
I just don't feel like I don't want this firm out there doing business, a licensed business anyway. Just because they want to have.
We have a lot of those people with failures. Or I don't know if we have a lot of firms. It may be individuals. But the firm itself has got to be the principal broker, I guess.
That's
right?
the problem, is when something gets a complaint against a firm versus the principal broker or affiliate. That muddies the water to me. But they don't know any better either.
So the complaint, the narrative says maybe a Tennessee Trek licensee. So we don't have a name, or we don't know.
It was I don't know if I put it in there. It was an anonymous complaint.
Respondent is the listing agency, but not an individual broker.
Maybe more appropriate to open a complaint against the principal broker.
Yes, did you say it didn't have it?
It says the complaint may be a Tennessee Trek licensee.
No, I was talking about the firm that was listed in number 14. I think you mentioned that maybe they were unlicensed. Did you state that? No?
Respondent?
Well, the type of license is a real estate firm, so I assume that there's a firm license.
Yes.
Okay.
I just thought for some reason. Active license.
Okay, so we'll go with the motion. And the motion offered by Mr. Diaz is to accept council's recommendation and additionally suspend the real estate firm's license. Do you want to define a period of time, Jeff? And really, this is only going to be an offer, and they'll certainly contest it, I would think.
Say we'll suspend it until 4/27/2022.
Downside to that might be if they do contest it, it may take that long to have a hearing on it. It may be
So I'm just wondering, is there another way around this to get to the outcome that he's wanting?
He's trying to get
What if we did away with this and open a case against the principal broker?
I'm sure that
They would know who that is.
We can find them.
find that out. Wasn't made part of this complaint anyway, but yeah, that's information that's ascertainable.
I guess I'm trying to get to what is the end game and back us back to it.
I guess then I'll change my motion. Then I'll make a motion to accept council's recommendation for case 14, and that they administratively open a complaint against the principal broker for this firm.
Second.
All right, motion by Mr. Diaz has been seconded by Ms. Franks. Steve?
Question. How do you have a respondent when there's no response? Can we call, I mean, is that?
Sometimes the respondent doesn't respond.
I know it, but that's not the right name. It's,
Oh,
I mean,
That's who the complaint's filed against.
It's legal speak.
No, they're still a respondent. The word respondent doesn't have to do
the response.
It doesn't deal with response. No, it's just petitioner, respondent, very similar to like criminal. Name. It doesn't do with their.
So that's I don't want to parse language, but that just
we can't change the whole legal
No,
department
it's like
today, though.
it's very similar to plaintiff and defendant, but instead we're using the words petitioner and respondent because the complainant has made a petition with a specific complaint and they're making the complaint against the respondent, which is a firm. But that word, respondent, has nothing to do with an individual responding. If you don't respond to a lawsuit, you are still going to be liable for those things. The court's not going to dismiss it. It's just like, it's a nomenclature.
Okay.
Non-responding respondent.
Non-responding respondent.
That's exactly right.
The reason I put that second paragraph in there was because, in my mind, if it's unresponsive, and they come back and say, "Well, we never got it," then that was sort of my idea is that just so the record was clear was that it wasn't signed by anyone. So the green card that's in the complaint is blank. However, the regular mail was undeliverable. So sending out a consent order offering to settle this for $1,000, that could potentially be something that they may say, well, we didn't. I don't know.
We didn't receive it.
We
It's
didn't
what
get
they
it.
always say.
Yeah. So, but not that that's really an excuse, but it was just sort of a little additional factual background.
Okay, so I'm a little confused here. We've got a motion on the floor to accept council's recommendation and secondarily administratively open up again a complaint against the principal broker. And if everybody's okay with that, we'll vote with one vote for both of those items. Any objection to that? If not, then if you're in favor of that motion, please vote aye.
Aye.
If you're opposed, vote no. That motion passes unanimously. Now, Marcia, number 18.
So number 18, the recommendation was a $500 civil penalty. This is an advertising complaint of and should be under the direct supervision of the principal broker. But the case is filed against the affiliate broker. So I'm okay with the $500 civil penalty for the affiliate, but I would like to add $1,000 penalty for the principal broker for failure to exercise adequate supervision.
We'd have to
open a complaint.
Yeah.
Okay, so I'm going to agree with, I'd like to make a motion that we agree with council's recommendation on case number 18 and that we open a case on the principal broker for failure to exercise adequate supervision.
Motion is seconded by Mr. Diaz. Discussion. Let's vote. Those in favor of that motion, vote aye.
Aye.
Those opposed, no. The motion passes unanimously.
3.
Number 23 I pulled is a timeshare complaint, which I very rarely ever pull. But the last paragraph says there's a good deal of back and forth between the complainants and respondents' conflict resolution department. In order to know what the complainants agreed to, it would be necessary to view whatever documents the complainants were given. My recommendation would be that we defer this for 30 days and ask the complainant to provide those documents.
So moved.
Motion by Mr. Diaz to do just that. Is there a second?
Second.
Second by Mr. Bagley. Discussion. Those in favor of that motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously. Number 26. This is more of a question than anything. So we have, I think, an on-site property manager. Is that who we're dealing with here? Who's this? This is Pam. So are we dealing with an on-site property manager?
That's unable to determine that.
If it is an on-site property manager, are they exempt from licensure?
They could potentially be exempt from licensure, but I don't have enough information to be able to determine that. This was one. There wasn't a response from the respondent in this case. Of course, there's unlicensed, so we can't penalize them for the failure to respond.
It's not failure to respond.
Right.
You're recommending unlicensed activity.
Right. Yeah, I agree with you that potential is there, but I don't have any information from which to conclude that.
Get that information.
Well, we've reached out to try to get a response. Normally in a situation like this, before I complete a summary and recommendation, I go ahead and try to reach out again to the unlicensed person to see if I can get some more information from them, which is something that I did in this case. It's something that if they had responded, we'd be able to evaluate that. But because we can't penalize them for failure to respond, the only option is to go forward based on the information that we have in the file, which is the complainant's allegation of the unlicensed activity. If they respond to that, that's certainly something we could administratively, if they responded to that and they gave that information to us to be able to conclude, oh, okay, I need to change this recommendation, that's something I could represent.
But what happens when they get this and they have $1,000 fine and they're like, I'm not dealing with this unlicensed. I don't need a license. They just throw it away and we never hear from them again. That's the problem.
That's a situation that I'm running into, and not this case. We haven't gotten to that point yet where, it's kind of a struggle to try to.
And then how do you collect that?
Address and have a big enough stick to.
You can't take the license away from them. What do you think we should do?
I'm okay with the recommendation. If you can't get the adequate response, you have to go with what the first appearance is. I think this might have been more for education purposes. If you could have determined that this was an on-site property manager, she would or he would not have needed a license. Is that correct?
If they were an on-site property manager and they met that specific exemption in the statute that sets forth that criteria, then they could very well have been exempt and may be. But I can't make that determination. I don't have that proof before me.
The respondent is a known name.
Yes, there was. There's some email correspondence that the complainant submitted and attached to the complaint, in which there was back and forth just regarding this application fee, and the respondent actually did respond in the email to the correspondence with the complainant initially. So they appear to be a known person with that name.
In part of the review, do you ever look those names up to see and that person wasn't licensed? Okay.
And do you have the name of the real estate development company? But they would know, maybe if you could reach out to them, they might know, yes, this, this is what our job is. The property management.
Send the offer here at the company to this respondent. I'm okay with.
So moved.
Second.
Motion by Mr. Diaz, second by Ms. Smith. Discussion. Those in favor of the motion vote aye.
Aye.
Those opposed, no. The motion passes unanimously. Jeff, number 27.
This is also a question. So when evaluating this complaint and you send it to the respondent, they respond to your initial battery of questions, and then you go back to them and you have further questions. If they don't respond to that second attempt, is that considered a failure to respond, or is that?
Mike's on.
Is it on now?
Yeah.
Okay. In this particular situation, the respondent did submit a response as required to the initial complaint before it gets assigned to the legal department. However, it was sparse and just a couple of sentences, which I've shared in the summary. For that reason, as Dennis was explaining earlier, there are situations where we need to go back to the parties. I don't automatically do that, but if I need some more information before I, figure out what the situation is and determine whether or not I think there's a violation, then I do that. And this was a situation where I had reached out to the principal broker for this company, and there was just never a response. So again, I'm back to, basing the information, basing the recommendation based on information that we have available, which was the complainant's information and what they provided as far as documentation that was attached to the complaint, including the MLS listing.
Your recommendation for failure to exercise reasonable skill and care, that would go against the agent?
It would go against the firm. That's who the complaint was against. Yeah.
So I make a motion to accept counsel's recommendation and administratively open a complaint against the principal broker for failure to respond.
Second. Yep.
I have a question.
Yes, Joe.
Anywhere in America that there's not electricity for 700 miles? Is this in the United States of America?
How wide is Tennessee? Like, what's the distance from Memphis to
About 400 miles.
Yeah, it's like 500 something.
So where in the state of Tennessee is 700 miles away from electricity?
So listen to Pam's response. I asked that question.
Okay, so the complainant in this particular case made an error in their units, and normally when I see something that's just blatant, I put a 6 so you know that when you read it. But I didn't in this case, so Chairman Grease had asked me about that, and I called the complainant and confirmed that it's 700 feet, not 700 miles. The nearest utility is not in Canada.
That's a big difference.
Across the country.
You work for the utility company or on the real estate commission or whatever. I thought the utility guy said, "Well, it's 700 miles away."
Yeah.
Being facetious, that could end up before any state board, and you could. So don't speak unless you can improve the silence.
It's called the gossip game.
Well, there's those SpaceX guys trying to get away.
Jeff, repeat your motion quickly.
My motion was to accept counsel's recommendation and to administratively open a complaint against the principal broker for failure to respond.
I have a question. Failure to respond to what?
Didn't
They responded.
the initial battery, but not the follow-ups. And that was my initial question. Is it
The what?
not the follow-up questions that Pamela went to?
The second time she called them.
So that's not a violation
No.
to ignore the second battery of questions.
No. It's that they have to respond to the complaint initially. If they choose not to speak to us at that point, it's not a violation of the statute or the rules, which is unfortunate, but
Still, you could still offer up one for the principal broker, though.
But let's. Oh, are you ready to counsel? You didn't want to, I know, but are you ready to?
Yeah, I'll change my motion then to just accept counsel's recommendation.
For a second.
Second.
Mr. Bagley seconds that motion. Discussion on the motion. Those in favor of that motion vote aye.
Aye.
Those opposed, no. The motion passes unanimously. Jeff.
failure to exercise reasonable. Is this a transcription error? The complaint said 700 miles instead of 700 feet. Is that what was in the MLS? 700 miles or?
Now the MLS didn't have any information. It led the complainant to believe that that utilities were available, and so the firm had listed the property on MLS as having a utility hookup as electric, and then once the complainant purchased the property and began investigating, it turned out that the closest hookup was 700 feet, not miles away, and that there was going to be a lot of work that had to be done through the neighbors and through the utilities in order to obtain easements and various expenses in order to do that. So the basis of the complaint and the recommendation, I reached out to the principal broker of that firm to ask, hey, what did you rely on? You know, what information did you have available? Did you double check it? And they didn't respond. So the only thing, they didn't respond to that, obviously, as we discussed. The only thing that I did have was the very brief response that they had sent in initially to the complaint that just said the principal broker had heard there may have been a problem with the power from the seller, but he didn't look into it because he didn't think it was a big deal. And I think that was insufficient, and that was the reason for my recommendation.
See how we do. Take a motion to administratively open a complaint against the principal broker for failure to exercise reasonable skill and care.
Second.
Second.
All right. Ms. Torbett seconds that motion. And the basis is on the 700 miles as opposed to 700 feet.
The basis is on the principal broker not seeming to be at all interested in resolving this matter for the client.
Discussion. Let's vote. Those in favor of that motion, please vote aye.
Aye.
That motion passes unanimously.
It's like, I didn't know it was illegal.
Yeah. 46. This is when I pulled it. Maybe this is particular to East Tennessee, maybe it's not. But here we have an agent who's advertising a 3-bedroom house, which is only permitted for 2 bedrooms. And her defense is that because she has all the disclosures to say it's only permitted for 2 bedrooms, it ought to be okay to advertise it for 3. And to me, this is false advertising at its best. Maybe better false advertising, but just a clear-cut case of false advertising to me. And I'm anxious to see what other commissioners think about that.
So it is 3-bedroom. It just
that's the gist.
And then you also come down to the discussion. I remember early on, Wendell Alexander was on this commission, and being from Franklin and the Nashville area my whole life, and my husband a developer and builder, I always thought that to say that there's a 3-bedroom house, it had to have a window and a closet in it. But I learned from Wendell that not every one of our counties in this state have those kind of rules. His I think didn't even have I don't know what you call it, a zoning, I guess, commission or something like that. So that's what stuck me up on this one is some people will call a bedroom when it's really, it's subjective. Do you think it's a bedroom? Not, and depending on which county you live in.
So, but where I land on it is the agent knows that it's permitted for a 2-bedroom septic tank, but still advertise it as a 3-bedroom house.
It's like, in my opinion, saying advertising is 3,000 square feet, but if you look at the survey down in the disclosures, it's 2,000 square feet. It's misleading advertising.
I don't know though, because if they're bedrooms, the septic permit doesn't affect whether it's a bedroom or not. See what
The septic says you can only have 2 bedrooms, not 3.
Yeah, but there could be a physically built bedroom, just like this closet is back here, And I had the issue with this too. I thought about pulling it, then I kind of erred on what Stacy's saying, because it does seem like the permits were on the MLS. Now, a buyer's agent should look at that and say, hey, just FYI, I would hope that the respondent had included language in the private remarks or public remarks that said this home this home lives as a 3-bedroom, but is only approved for 2. If that was included, I have zero issue with it.
That's what I would have. That's the way to do it, because you could take a bedroom and split it in half, and make one bedroom into 2, and if they didn't pull a permit, that's all they did. It's a bedroom, but it's only zoned for 2.
It seems like they made it seemed like the respondent made an attempt to make all the disclosures, because they said they were readily available. There were 15 offers, whatever. I think, as I see it, it's up for discussion. As I see it, the best practice is just as I described. I don't know if that was done.
And just because the previous seller sold it as a 3-bedroom house, it doesn't mean that the next one should make the same mistake.
I don't know. I have a hard time. Sorry. I have a hard time with that because, I feel like the septic permit is really unrelated to if it's a bedroom or not. You're just basically saying the septic tank's probably not going to accommodate this.
No, that's not. It's not an opinion. In my county, in Williamson County, if you're on septic, you have to go get a septic letter, and the septic letter says this land only perks for a 2-bedroom house. But if you build a 3-bedroom house on it and then want to sell it, you still cannot say it's a 3-bedroom house. It's only a 2-bedroom, unless you disclose that it only perks for 2 bedrooms, but we have the 3rd bedroom.
It looks like that's what happened though. They signed a septic.
That was on the MLS.
There is, John, the residential side, we do have a disclosure that puts it back toward the buyer side, in my opinion, is that,
this house on the septic tank, here's what we know, and anything else you need to.
So here's my picture. I don't do residential, but let's say an average, she puts new listing, 3-bedroom house, and the public reads that. What do they think they're getting?
It's lawful. They think it's lawful.
It says the respondent here. I'm rereading this. It says the respondent. Complainant alleges respondent had already completed the MLS document when she discovered the septic limit and chose to include a private MLS comment. So it sounds like she had made the remark that I often see, and I don't know that I've made that remark myself about a listing, but it's the remark you need to make. Williamson County says this is 2, or I'm just using it because, for example, Williamson County sewage disposal says 2 bedrooms. It's tough.
It says she was given an opportunity to walk away. Decided to make decided to ask for furniture instead. So she knew what she was getting. It was all disclosed. I don't have a problem with it at all.
Why don't you make a motion?
I'll make a motion to accept council's recommendation.
All right, there's a motion from Ms. Torvik to accept council's recommendation. Is there a second?
Second.
Jeff Diaz seconds the motion. All right, everybody clear? If you're in favor of that motion, please vote aye.
Aye.
If you're opposed, vote no. Chair votes no.
To your point, John, going back through this, when she put the private remark in, she should have changed the MLS. So private 2 wrongs don't make a right. And you're right.
But we're going on. We're going on to number 49, Mr. Diaz.
Yeah. My issue with the letter of warning is that, this gentleman, this licensee is in a different state, practicing real estate in a different state. He no longer has a license in the state of Tennessee, so I don't see what good a letter of warning is going to do. So I'd just like to make a motion to dismiss this case.
But the case was opened in June of 21.
I just think the present circumstances are that he's not here. He doesn't hold an active license in Tennessee. He's in a different state. I mean, I don't know what good a letter of warning is going to do for him.
Well, so is it unlicensed activity then?
Can you hear me now? Apparently I don't know how to operate this. I don't think there's a wrong answer in here and what you're suggesting either. In taking a look at what was provided, where the information stating that he was still suggesting that he was still operating in Tennessee, or he was still a Tennessee real estate agent, it was not on a public facing type of forum. It would have been something that other real estate agents would be able to see, because the letter of warning would be, if you chose to do one, would be more in line with what you're saying, not just the internet advertising rules, but hey, you need to scrub all of this because here's the rule on, unlicensed advertisement, just to ensure that he does that. But we, could just as easily close and flag.
It's more or less building a record than anything else.
That letter of warning specify to clean up your internet? Is that what the letter would say?
Say we're going to flag it in case he comes back.
However you want to do it.
I'll make my motion to just accept council's recommendation.
Is there a second?
Second.
Thank you, Steve. Those in favor of the motion to accept council's recommendation, please vote aye.
Aye.
Those opposed, no. And that motion passes unanimously. Number 50. I like everything about council's recommendation here, except part 2, where council suggests a $500 penalty for violation. In other words, making an offer, a guarantee that doesn't have all the details included in it. And I think we've been fairly consistent hitting that at $1,000. So I would suggest, from my perspective, it ought to be a total of $1,500 civil penalty, $500 and $1,000 for part 2.
So moved.
Makes that motion. Mr. Perez seconds that motion. Discussion. Those in favor of that motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously. And number 54, Jeff.
More of a question. At what point, this is the agents working from home question. Council's recommendation was to close. And I guess my question is, at what point does an agent work from home become an office? Do they have to have their own phone number? Do they have to take meetings there for the purposes of real estate? Does the statute give us any guidance there?
Has to have a sign outside.
First would be a sign.
If they're, and Anna might be able to speak to that more too. I know that in this particular situation, the page that was a screenshot of this website, which again is another non-trade organization, non-public facing web page, did not designate an office address, or that it was just a very strange page where you've got different thumbnails of maps, and one very clearly designates this is the office, and then there's some other addresses that just have a link where you could see a map, and there's not even a physical address listed. It just says work from home. So I had gone in, to the extent me as not a member of that organization, and a representative of the public who might be looking this person up on this web page, and the only information I see is her actual office address in this situation. So it was a bit strange for me, and didn't seem to rise to the level of her representing that she had other offices. The way it's kind of hard to explain without showing it to you.
Right. I mean, because in a real sense, most agents work out of their home. I mean, they go to the office, or a car. They go to the office every, once, twice a week for business meetings or as needed, but they're usually out and about or at home or anything like that. So, I just wanted to clear in my mind if there was a threshold, and so a sign with a. So if they put like an agent on duty kind of sign, or is it like a firm's name? There. Is that? Does anybody have any thought on that?
That's the firm name sign, right, Marcia? And a broker has to. That's the way it used to.
Because I recall we had a case earlier where an agent had a private office that he went to and he worked out of. He wasn't doing any real estate business there, but somebody accused them of having an unlicensed firm. And I think it was very important to us that he wasn't taking any business calls there. He wasn't doing any real estate business out of that office. It was just a private office that he went to. And I don't think we dismissed that case. So I just wanted to see if that line had moved at all. And it doesn't seem so. So I'll make a motion to accept council's recommendation.
By Mr. Diaz, seconded by Ms. Torbett, to dismiss per council's recommendation. Those in favor of that motion, vote aye.
Aye.
Those opposed, no. Motion passes unanimously. All right, council, anything else to come before us?
Yes.
It's not the right answer.
Not the answer you're looking for.
Sorry.
Bless her heart.
John, why'd you ask that question?
I know, my fault.
I'm gonna say it anyway. I have an update about rules. So the rules pertaining to criminal convictions were supposed to become effective this month. However, that is not what happened. The rules were withdrawn due to a statutory change in the Fresh Start Act. All of the information that was provided in the rules to amend it to make it look like the statute, that part was taken out. So I found out one day before we had to go to DevOps. So the rules at this point have been withdrawn. We'll come back to you with more information about what we're doing, if anything, regarding it. But those rules have not gone into effect.
What was the rule change?
So the rule change removed the all felonies language, and it amended it to the felonies that were listed in the Fresh Start Act. Well, in that act, it was amended during the General Assembly legislative session. That part was left out. So we were referencing a part of a statute that no longer exists. And then also it impacted, I think it was question 2 or 3, that has the 2-year bar from sitting for an examination before the end of probation, incarceration, whichever is later in time.
How long has that rule been in process? More than a year, right?
It's been a long time. It's been a long process, but we didn't have information about it. It was part of a package. So if we do anything, we'll have to amend it because the language is moot at this point.
We're all the way back to step 1 then?
Yes, we don't have any rules.
Step. All right. Anything else, Anna? Caitlin?
Nope, nothing further.
Your staff is good.
Caitlin?
I just.
Oh.
You thought
Staff
you
is
just
great.
shut me down after you said nothing else. Your staff, everybody's good.
Everybody is good. Yes.
I'm still not getting complaints, which is a good sign.
Good. Yes.
Keep it up.
Yeah. No, I think there are. No news is good news.
Dennis, we're glad you're back with us for however long a period of time it is. It's good to see you. Commissioners, anything to say on the way out other than safe travels? We're adjourned. See you next month. Do you need help with that stuff? To your daughter?
No.
Sure.
There's a lot of kids.
Okay.
Release them.